is up, everybody? Good morning. Karen Reed. There's day one. So let's go back to this. Oh. This is just the introduction. It just keeps playing on repeat. So join. It's really interesting. Anyways, good morning. We got some whack stuff going on right now. Okay? We got some whack stuff going on right now. Turtle Boy and Karen Reed are supposed to be in the court together at 9. So we're about to find out what's going on. 2 hearings this morning. Turtle Boy first, then Karen Reed. Yeah, can you believe this shit? Look at the fans on, you guys. Is it the fan? The number one fan? I have an inside source. An inside source says, what the fuck is Karen Reed thinking doing these interviews? I think there was an emergency motion put in. They're trying to take their phones. Yeah, they're trying to take their phones because of the freaking document drop. I mean, not the document drop, because of this documentary that dropped. I got my mind all on Colbert right now. Okay, guys. Yes. Sherry's like, yes, that's exactly what's going on. Yeah. And there was, I believe, an emergency motion filed. And, I'm starting to dub the Karen Reed case. You guys, I'm seriously, it is like watching General Hospital. You guys ever watch soap operas? Like, the Karen Reed case has become literally a soap opera. Like, it's crazy. There is more action though. It's like a Friday. General Hospital Fridays used to be like lit as a tit, and then everybody had to wait until like Monday to get it. It was just like cliffhangers. Every time we're in court for the Karen Reed case, it is a Friday of General Hospital. So I just want people to know that that's what's like. This case is just. Now we also have a source close to the case that says that was not supposed to come out when it did. So I'm curious about that. I'm curious if at the last minute, these editors, that's why I did not do, what was it? The Paramount the Paramount documentary with the Brian Colbert case. I talked to these people for like ever. They kept calling back because I had like my plane ticket, I had everything. And the last minute I was like, you know what? I'm out. I didn't trust the editing process. And I had really good people that I talked to make that decision that I wasn't going to go. And I meant no disrespect or whatever, but I just couldn't afford to have like, they wanted all of my work without any questions asked. Like they could just use whatever. And I said, excuse me, like, no, you're not having full access to my shit. And you're not going to make me out to be some crazy person. Like, no, I didn't trust it. I can make my own documentary, and I will. Because all I got to say is I nailed all those docs. Becca Barlow and me were just dancing. I'll be talking about Brian Colbert today at 6 and 9:30 tonight. But I think that they just went ahead and they aired that. I think that was coming out later. And, she said that this is my testimony. So it was like for anybody saying that like they wanted to hear my testimony, or like why I didn't take the stand or something like that. I don't know. I can't believe that BK's pig is super creepy. Yeah, but he has no blemishes. How about that? For somebody that just got an altercation with 4 people Looks like he's always had a missing shower curtain. I'm sure Karen thought the trial was going to be over. Yeah. I'm telling you, we know for a fact that Alan Jackson would have had no problems calling up the person and saying, you need to pull that and you cannot air that. Okay. And then they went ahead and they did it. They aired it regardless because, especially with everything that just had happened. I mean, you can get stuff pulled, but when you're dealing with money, okay, people don't give a fuck. And it's sad because this is someone's life. And here they aired something again, and this is my opinion, but we have some people that have hinted towards that was not supposed to happen when it did. That was not supposed to air when it did. Shower curtain is there. Murky, I was kidding. Murky, I was like, girl, the stuff I'm about to blow out of the water in that case this coming weekend is gonna lift up your camera. Let's go, guys. Get pumped this morning, okay? We got the Wild Wild West coming in here. You know, when we plan for something in the Karen Reed case, it doesn't happen the way we plan it. Like, that's just not how it goes. So Turtle Boy, Karen Reed, they want their phones, but more importantly, guys, it's due to what just came out. What just came out was that there was hinting in episode 4 that Karen Reed was cheering on Turtle Boy for the stuff that he was doing. You guys, that's like me cheering on the Cavs. All right, I want my Cavs to win. Right, I didn't have anything to do though in the game planning of my Cavs winning or wanting them to win. Or I could cheer on that I want, you know, P. Diddy to go down with all these scum-sucking, greedy, like you have all this money, you don't know what to do with it, so let's just start doing it like this with our money. So I want to hear some facts. About this whole Turtle Boy, Karen Reed conspiracy. Well, some folks are already saying it isn't there. They have cropped the pic. They can crop my tits. Let's take a look though. I want to, Bev, she's going to be a minute, trust. Let's go take a look at, I want to say hello to Tom over there in the gang. So let's do this. I'm going to get out of this, go here. And I want to share this. And let's go say hi to Tom and the gang. Let's see what's going on over here.
Yeah, I got it. Thanks. One morning.
Okay. We'll get a little rewind here.
She got trusted driver. That guy. That is her. Yeah.
What you think I rap for to push a fucking RAV4? Look at that Range Rover.
That's her. I think that fits that.
All right, let's see what else. I want to see. I'll try to show this area that I was interested in. Okay, see where that, right there where that cop car is? All right, right there, perfect. Off to the right, right there, that's where you walk right there on the path, the sidewalk, and then right off there to the right is where you're going to go in to your, to the courthouse, right? Well, right where that cop car was parked, this big old van was for one of the news stations. I can't remember if it was 10, News 10, if it was 25. I can't remember. But they parked there the whole entire time because I was like pissed. I was like, I would think that they would leave, at some point so I was hawking the spot because I wanted to put the tailgate right there, okay? And notice here, there is no big old van with this news, and it's this cop car, Troopa. So that's whenever you hear me talk about this van and where it was parked, I just want everybody to see that's where that van parked. and it was so big that it like fucked up our like see around it and see people. It was actually, honestly, it was dangerous. Like, you want to talk about like not being able to like check out your surroundings. I didn't like that van being there. It was dangerous. I want to see if somebody pulls a gun, you know. I don't want people hiding behind no fucking van. It's huge right there. So anyways, that's where that cop car is right now. So I hope that actually stays like that. It'd be better for everybody's safety. So what's going on today is breaking news in the Karen Reed case, because it's every day is a Friday. In the Karen Reed case, like General Hospital Fridays, they were always off the hook. So every day is Friday in the Karen Reed case, because this morning Karen Reed's going to have to deal with something that wasn't expected, which is due to this documentary. You know what? Again, Karen's damned if she does, and she's damned if she doesn't speak. Because you always have those people that say, if you're so innocent, why aren't you screaming it from the rooftops, okay? Well, when you go scream it from the rooftops, right, then people come back on you and want to nitpick everything that you say. That's why I'm of the belief, and I will always be of this belief, that we are given this right, which is you have the right to remain silent. What's the rest of it say? Because anything that you say can and will be used against you. We wouldn't be afforded that right if it wasn't a very, very important right. And so I am of the opinion that if I want to be vocal, I'm going to do it through my attorney. Like, let my attorney run at the mouth. Okay. Obviously, if there's a gag order, you know, they can't do that. But anything that you can, like anything that you say, it's going to be used against you. It's never going to be used as a positive. When have we ever seen, except for maybe on Dateline, after the fact, after they've been, you know, cleared, when you watch Datelines and you actually like get to hear this person's story then, okay, and everything that they went through. There's always going to be a day that you're going to be able to tell your story, but I do think pre-ejaculation is a thing, and I just recommend you have the right to remain silent. It's a very powerful right, very important right, because all these wackies, the media, they're going to spin whatever. So, but this is, I think that they tried to pull that ID series, and I think ID said, get fucked. I think that when you don't have any say in how that shit goes, you know, post-production, that's why I backed out of that Paramount deal. I said, I'm out. No way. No way am I going to let these people follow me around with a camera, microphone, have nothing but cameras going the whole time, and God forbid I say something that they choose that they want to use, versus like when you're doing like when you have like that sit down and you're asked a question and then I answer that question. You're not going to have some background where you're saying whatever and then you show a clip of me doing something. No way. That's out of context. Like, get straight fucked. You want to know about me? Come on. I have a channel. Come on. Let's go. Let's roll. Yeah. And I think my approach to that would be, you know, I have a right to remain silent. And the reason that I am remaining silent is because of the media. You guys will spin anything and everything I say, period. That's what I would say. Every time. I'd fucking spin that shit back on the media. Go sit and spin. I would document everything that I was doing. Like, have my people around that, like, it's my shit. I own the rights to it. If I want to release any of that shit, it's on my time. It's on, I call the shots. So, but shit's going to get wild.
He says he would never talk to us. And yeah, she can.
So like all these signs and stuff, they're not going to be able to be there.
I think just a second. All the other law tubers out there looking at this, saying, what is this?
What is what?
I haven't seen Grant, and I don't even want to talk about it, but I haven't seen him in weeks, so I don't know what's going on there. I'm sure.
So they just kick her home from there, right? Yeah, you can put the
All right.
Tom. Yeah, all right, never mind.
Oh, you have an extra?
I don't have an extra one, but I'm not.
Karen, there's I thought these mics aren't supposed to be on. All these fucking ruiners. I need to get out of that horrible stream. Okay, so let me go like this. I'll just go like this. Okay, so that. Damn. Okay. Can you guys hear it? This is audio. So right now we have some audio. I don't care if we can't see anything as long as we get this audio. Don't tell anybody. We got some audio over here though. Great. Good morning. Excellent. Excellent. Let's take a look at my. We got some clarity though, guys. Ready? So I'm gonna keep this. I'm just gonna turn it down a tad. We have, remember the defense witness list I was talking about? So Matthew Kelsich, that is the ATF agent and best friend of Brian Higgins. He is on the list. He is the one that supposedly helped Higgins, download his phone and all that shit. Okay. So He's the one that illegally accessed FBI forensic equipment to help Higgins manipulate his own cell phone data before he turned over a highly curated extraction of his text messages with Karen Reed and John O'Keefe. The edited messages that Higgins gave to the police were, unsurprisingly, very prejudicial to read, painting her in an unsavory and unsympathetic light. Next, obviously, we know who the DA is. Morrissey recorded an unprecedented video press release in which he claimed Karen Reed was guilty of murder. Michael Proctor had no connection to the Albert family, and all of the witnesses in the case were upstanding and 100% innocent victims. Even the presiding Judge Canone officially reprimanded Morrissey for making such improper and unethical public statements about a criminal defendant before trial. Meatball was also caught using a private email account to complain to the judges in Norfolk County about Aiden Kearney. Yeah, same guy from the Aaron Hernandez case. Yes, there is footage of him. I played it on the channel of his when he testified. Helena Rafferty, the chief may be implicated in the alleged hiding, manipulation, and editing of surveillance camera footage from the police headquarters on the days surrounding John O'Keefe's murder. Thomas Keller, deputy chief of the Canton Police. Keller lived across the street from Brian Albert's former home, 34 Fairview, the scene of the crime. Keller's security camera oddly recorded nothing that night. He is also the source of the infamous red Solo cups with which the Canton Police Department officers collected blood samples from Brian Albert. Sherry D was loving that. I'm loving it. Paul D. Gampitro. He is a Canton Police Sergeant, was before he unexpectedly retired this year at the ripe old age of 56. Oh my God. Told you guys, this is freaking days of our lives. All my children, General Hospital, the rich and the famous, or the young and the restless, whoever the fuck they are. This is literally all of it. This is a soap opera, man. Okay. Like, where's Sonny Corinthos? I want to see Sonny Corinthos in this motherfucker. Okay. Love me some Sonny. You know, Jax from General Hospital. That's who my son was named after. Just Jax. My son's not Jackson. His name is Jax. Jax. I want to see Jason Morgan come on this bitch and just start bouncing people. Basically, Turtle Boy's Jason Morgan. Boston 10's YouTubes and Long Crimes YouTube Court. If you need another feed, got it. Yeah, it's only 9:05. Bev's on the back. So Paul, this ripe old age 56 retiree from Canton police officer who allegedly downloaded all of the relevant police surveillance footage to his own computer and then didn't tell anyone about it. Or if he did tell someone, they didn't tell the defense about it. Jeffrey Kostakowski. Remember, I was like, who the fuck's that? Massachusetts State Trooper Kostakowski was a colleague of Proctor's in the DA office's MSP troop. Interesting. Annie Chung. Everybody was Chung fighting. Well, she is the Canton resident and the next door neighbor of Brian and Nicole Albert. Yes, the owner of the Asian house, the Chungs. Love it. Told you guys that. Okay, remember I was like, who the heck is Maggie Gaffney? I was like, I want the I I want the last name Gaffney. Remember? All right, we're gonna bring it up here.
Just a heads up. Does she have it? Okay.
Here we go.
I love how we all help each other out.
Fuck yeah, everybody's helping each other out.
It's cool. You are unmuted. Oh, good
Look
job,
at-
Kelly. And wow.
Look at Bradles in there.
Thank you, Sammy, too.
This is so unbelievable.
And, Shelby, long time no talk. Good to get on here, girl. Hope the kids are good.
He's
Hope your
wearing
boyfriend's doing
pink.
good.
He's wearing pink.
All right, so how do I get this to
This is in a different courtroom.
see if okay.
That's why. That's why.
Okay.
This is in a different
Okay.
courtroom.
Um,
This is in a totally different courtroom. That's why there's no cameras in here. Oh, they're all rising.
so it's the Zoom. I have the code. If I don't know how to get it to Melanie though, because I don't have her email. I just sent it to Bettero, Melanie. If you can, yeah, I don't know how to send it to Melanie, but I just sent it to Bettero. If Bettero can let's stand it up. Are we unmuted?
Mike, we have a hot mic.
Okay.
Mike, it's you. All right, now they're all sitting. All right, well, someone's got to click the button. Come on, tell me we're going to get
You
volume.
said no volume. I don't know what's going on.
I think they have to click it.
That sucks. That's a bummer.
It's okay. I'll give the play-by-play. Well, good morning, ladies and gentlemen.
Okay, well then go over to Melanie's then. I don't know what to tell you.
But,
Go
What?
over to Boston Tom's, but I'm not sniping.
tell the glare that I sent him the Zoom.
Oh God, it's the glare. Then go over there. I'm not.
There you go. You got it. Boom.
Oh, we got audio.
May. Your Honor, what the Commonwealth is seeking is phone data on 2 phones that were seized in search pursuant to a search warrant, and those phones are involved in the case of Commonwealth versus Carney. And before you is Mr. Carney and his counsel. From the public available pleadings, what I've learned is that there were search warrants for Mr. Carney's phone. 6 search warrants were seized. 2 of those phones were searched pursuant to the warrants. They did not have any limitations such as a paint team, and they've been, according to the public pleading, thoroughly searched. The other 4 phones, we are not interested in pursuing any information on the 4 phones that have not been searched yet. The information on those phones, as I understand, is not subject to any protective order. It is in the custody and the control of the Norfolk County District Attorney's Office. Frankly, I don't know if a Rule 17 subpoena is necessary in this case. I've searched the case law. I do not see any case law that specifically says under these circumstances, a Commonwealth lawyer is obligated to obtain a Rule 17 subpoena to pursue or obtain other information available in a separate case. But these are a bit unique in circumstances in that I am a specially appointed prosecutor to Karen Reed's case, Commonwealth versus Karen Reed, and Judge Cosgrove, Special Prosecutor Cosgrove, is specially appointed to Mr. Carney's case. Because of that, I have, from the beginning, kept a very strong line of separation between both Mr. Carney's case and Ms. Reed's case. I have only sought information that's been publicly available. That's why my motion cites a search warrant, an affidavit in the search warrant, and there are 2 pleadings as well in my motion that are on the public docket to Mr. Carney's case. Because of that, I have
from the beginning, kept a very strong line of separation between both Mr. Carney's case and Ms. Reed's case. I have only sought information that's been publicly available, and that's why my motion cites a search warrant, an affidavit in the search warrant, and there are 2 pleadings as well in my motion that are on the public docket. And so what I learned is from my public reading and from watching hearings. And so what I know is that there are 2 children that were searched by Trooper Tully and is in the possession of the Norfolk County District Attorney's Office, and the information is relevant material to Karen Reed's case. The reason why it's important and relevant is that separately, I possess information that establishes not only a relationship between Karen Reed and Mr. Carney, but a relationship in where information, some of it private, some of it suggestive grand jury minutes, was passed purposefully from Karen Reed to Mr. Carney. Originally, a third party was used, an intermediary, where allegedly Ms. Reed would send the information to the third party, would then be sent to
Counsel, let me stop you there. Has the name of the intermediary appeared in the public record?
I don't know that. I know that the attorneys are very well aware of that person's name. It may be, but I don't know that, and that's why I've refrained.
Let me ask you this, Counsel. Does the name of the intermediary appear in Trooper Tully's affidavit, either in the substantially itself or in the addendum A?
I will need to re-review, but it very well may.
Well, that's a critical issue here with regard to the purported relevance of the data sought. Let me ask you this, Attorney Brennan. Have the extraction reports that have been requested been generated?
I understand they are available to Special Prosecutor Cosgrove, and that they have the reports that have been generated.
Has the underlying data from the 2 phones in question been assembled?
I understand that it has. I cannot personally confirm because I have not asked to review it personally.
Do you know the volume of the underlying data?
I have no idea because I've purposely not asked to see it or ask questions about it.
Okay. Please elaborate on relevance as it relates to consciousness of guilt.
Yes. As Your Honor is aware, consciousness of guilt is a different standard than trying to prove a case of intimidation of a witness beyond a reasonable doubt. What we expect evidence will show, separately and in Mr. Carney's phone, is that there was a relationship between Karen Reed and Mr. Carney, in which Ms. Reed would provide information indirectly to Mr. Carney. That information would then be reviewed by Mr. Carney, posted on social media, and consequently was used, we believe, allegedly, to intimidate and harass witnesses. In the search warrant itself, there is extraordinary detail on how Mr. Carney targeted witnesses in Ms. Reed's case, with the express purpose, according to Mr. Carney, that this trial of Ms. Reed never go forward. We have a many-page affidavit that we have provided to the court. I can offer some of the most important parts if Your Honor would like.
Counsel, I don't think that's necessary. I've reviewed the affidavit in support of the search warrant thoroughly, and here's where I struggle. So the case law says the party seeking the data in question has to make a initial factual showing that it's relevant, not potentially relevant, relevant. That's the initial burden. So to demonstrate her alleged consciousness of guilt, defendants, don't the communications sought or the data related thereto have to only involve communications between Mr. Kearney and the defendant?
I'm not clear on your question, Your Honor.
How is anything beyond communications between Mr. Kearney and the defendant in this case relevant to her consciousness of guilt? Here's my issue. You have sought a broad swath of data. We don't know the volume yet, but it is from the addendum A to Trooper Tully's affidavit in support of the search warrant. It calls for data including calendars, alerts, reminders, notes, text messages, pictures, or videos from April 1st, 2023 through including October 5th, 2023. 7 months of material that ostensibly could include everything from
That's what happened to Brian Colbert.
meeting notes, calendar invites, texts, videos, things that have absolutely nothing to do with communications between Mr. Kearney and the defendant. So how can the Commonwealth make the threshold showing that those are relevant?
First, this is a ruling with Mr. Kearney, so I'm asking that Mr. Kearney and his attorney be at the table. I'm not sure why we're being joined by Ms. Reed's team unless they have standing in this.
We're a little confused, and I don't mean to interrupt the proceeding, but as we'll.
Can you state your name for the record, please?
Of course, I'm sorry. Alan Jackson on behalf of. We didn't see which case number was called. It was Rule 17, if it was Mr. Kearney's case number, or if it was Ms. Reed's case number. We were told, or at least our impression in talking to Judge Canoni, was if this issue was going to be on our case number. I specifically asked that question at sidebar day before yesterday, and she said, yes, the Rule 17 Mr. Brennan's dealing with is on Ms. Reed's case number as it pertains to her rights. And the issue is,
Counsel, Counsel, it has been called in this case, but I don't know that your client has standing with regard to this particular issue.
So the case number, I just want to make sure procedurally I'm on the same page as the court and Mr. Brennan and Mr. Kearney. The case number that was called was the Commonwealth versus Karen Reed.
00117.
Okay.
That's correct.
Then she needed to be here, and she has right to counsel, and we have a right. We believe we have a right to be heard on this issue because it does attend to her rights going forward in terms of her case. I mean, this is her case.
I don't know that yes, it is her case, but what standing does she have to challenge a Rule 17 request related to documents produced in another case?
Because it specifically pertains to the prosecutor asking for information in her case to move forward, her consciousness of guilt, etc.
Those are evidentiary issues, counsel.
Correct, but
which can be dealt with at a later time. Those are what you're suggesting are evidentiary issues which are not before the court. All of it before the court is a Lamprin hearing on material sought from Mr. Kearney's case. The evidentiary issue will be dealt with at a later time.
I understand, and respectfully, I don't necessarily disagree that from an evidentiary standpoint or the admissibility standpoint, that can be dealt with at a later time. But the case should never be called without my client being here. She has a constitutional right to be here and to be heard, even on a Rule 17. The Commonwealth there's been Rule 17s for 2 years on this case, over and over again, Your Honor. The Commonwealth has taken positions on Rule 17s. We've taken positions on Rule 17s dealing with third-party information, be it cell phones or text messages or whatever. I'm only asking that we be entitled to be heard on this issue, even though it deals with Mr. Kearney's phone and he's got legal representation. It also attends to Ms. Reed's rights, and it's her case number. And the reason the Commonwealth is trying to bring it in is to deal with her case, not Mr. Kearney's case. So she has to have a right to be heard.
Counsel, this motion's been pending for a week and a half now. Correct. I don't have any opposition from you. I don't have any submission from you.
We intended to submit oral argument as it attends to, and we're prepared.
Did you give the court notice of that?
We did to Justice Canoni.
Okay.
Day before yesterday.
And what do you propose, counsel?
The only thing I propose, I don't want to interrupt Mr. Brennan's argument, but when Mr. Brennan is finished, Ms. Little is prepared to address the court on the very issues Mr. Brennan is bringing up.
I'll take it under consideration. Is there any issue, counsel, with the current configuration, the court, such that that causes any issue for any of the parties?
No, absolutely not, Your Honor. Again, I will step back. I will be a little mouse in the room. I just need to be in the courtroom. And once Mr. Brennan is finished, before the court makes its ultimate ruling, and once Mr. Radel is finished, I think we should be provided an opportunity to be heard.
I'll consider the request.
Okay.
Because I have no objection procedurally, the council wants to join in my file. That's an issue in terms of the file.
in this case, and I'll allow her to sit at council table and to have representation, and I'll consider whether I'll hear from her counsel concerning the substance of the motion and her
Thank you, Your Honor.
considerations there
We
too.
appreciate the court accommodating us.
So, ADA Brennan, with the court's apologies for the interruptions, the crux of the issue, as I see it, with regard to relevancy and the Commonwealth's burden at this stage to show that the requested materials are relevant, involves the breadth of what has been requested. And perhaps you could speak to that and how materials that would be swept into this request are in fact relevant.
I understand the court's concern, and I've looked at Addendum A as well, and have identified the information I think is relevant to the Rule 17 subpoena. So I agree the Rule 17 subpoena speaks broadly, but what is relevant is sections D, E, and F. Now, mindful that there was probable cause to obtain this warrant, which is a far stronger standard than what is needed for a Rule 17 motion.
Counsel, pardon me, did you say D, E, and F of Addendum A?
Yes. So if we look at Section D, there was probable cause granted for communications between Mr. Kearney and any witness or family members of witnesses involved in the murder of John O'Keefe, to include but not limited to Matthew McCabe, Jennifer McCabe, Brian Albert, Christopher Albert, Colin Albert, Juliana Albert, Michael Proctor, Elizabeth Proctor. And so limited, including but not limited, would suggest any witnesses in the Commonwealth versus Karen Reed case. E is pictures or video depicting evidence of intimidation of a witness. So similarly to D. And F, data evidence disseminating data depicting evidence of intimidation of witnesses of those same people. And so D, E, and F are squarely on point and relevant to the Commonwealth versus Reed case. If there is probable cause to obtain a search warrant, believing that there is information of those three categories on those phones, then I believe we're entitled because we'll clearly have met our burden of proof, not only because a Rule 17 is that it's likely relevant, much less than probable cause, but because of all the attendant information that we've provided. There is...
Hey, Brennan, let me stop you again. Would any of those categories include communications from Mr. Kearney with counsel from Ms. Reed?
No, I think those would be privileged. Secondly, there are motions filed in this case, not Karen Reed case, Mr. Kearney's case. One is the Commonwealth's opposition to defendant's motion to suppress and to restrain any searching of a computer or telecommunications devices. This was filed by Special Prosecutor Cosgrove. And in that motion, on page 5, he notes that the two phones that I'm seeking information from have already been searched. And he also notes in the motion that there does not appear to be any attorney-client privilege materials. There is a second source as well, and that is in the Commonwealth versus Kearney case, docket number 53, Commonwealth revised proposal for examination of digital materials seized. That's relative to the 4 phones that I'm not seeking. However, it's instructive because in that motion as well, it talks about the history, and it gives assurance that there are no attorney-client privilege communications in the 2 phones that I seek. And so, given the separate evidence that we have, and these are clearly witnesses in our case, and the admission by Ms. Reed herself, I do not have the video, but she was recently on an air broadcast on a documentary last night, the night before, and the night before. There are admissions that she was, in fact, providing information to Mr. Kearney. And what is notable is that she specifically reflects upon the consequence of Mr. Kearney's actions, which she helped fuel by providing this information and identifying the witnesses in her case. I do have a clip, if the court is interested, because it gives great depth and understanding to the intentions of the party in sharing this information. I have a clip available. If the court wants to hear it, I can play it for the court.
I don't think that's necessary, so I'll decline respectfully the offer, ADA Brennan. Thank you.
And so in light of the fact that this information was seized pursuant to a warrant of probable cause, in light of the proffer in the affidavit, in light of Ms. Reed's admissions of the sharing, inevitably, the obvious consequence to witnesses, this is relevant to consciousness of guilt. The evidentiary basis is clear. I do not have access to this material if a Rule 17 is necessary. And again, I've filed the Rule 17 out of an abundance of caution to be beyond reproach. If it is not necessary, I will simply go and obtain the information on my own, but I think it's more prudent to have a court order. It's necessary before trial. I'd like to review the materials that are relevant, and I agree the scope should be limited to D, E, and F, not the entire phone. And those materials will be provided to Judge Cannoni in a motion in limine regarding consciousness of guilt. Also, we'll dictate what witnesses we call at trial, which advance notice is important for both the Commonwealth and for the defense. It's in good faith. I provided both pleadings from Mr. Carney's case, the search warrant, affidavit in support of the search warrant. I've offered videos of the admissions by Ms. Reed to the relationship. And so for those reasons, I ask you.
Counsel.
Thank you very much, Your Honor. Good morning, Your Honor, counsel.
Morning.
Judge, this is a Lampron request, is the case, and I know you're familiar with it, Your Honor. The purpose of the court's focus here, Judge, is on preventing unwarranted harassment of witnesses and third parties. The focus in Lampron as well is avoiding unwarranted delays. So this search warrant was done back, I believe, in February of 2024. So here we are at the 11th hour, and the Commonwealth is throwing, last-minute bombs out. I happened to look at the Reed docket last night. It's amazing to me how many motions in limine are filed. The government's trying to try that case through motions in limine versus, the immediacy of a trial. It was my impression of that. So, we're now getting sucked into these motions here at the 11th hour. And in terms of a Lampron analysis, Your Honor, there's relevancy, evidentiary, meaning it has to be evidence. As you said, not potential relevance, but actual relevance. Not otherwise obtainable at trial. You can't prepare for trial without it. And most important, Judge, is that the application is made in good faith and not as a general fishing expedition. This is the ultimate fishing expedition, Your Honor. And I want to go back. When this happened, Judge, we didn't have a dog in the fight back then. As far as my client and I knew, they were going after Ms. Reed for communications with my client on this witness intimidation issue. Well, counsel wants to tell you that, there was probable cause in a search warrant, but then they took it to a grand jury, so we're past that. They had the two easiest forums you can have for a prosecutor. Sitting in the judge's lobby, shooting the breeze with a search warrant affidavit in front of you and nobody else there. And then they went to the lowest hanging fruit.
You, not me. When you say you, not me.
Right, not you, Your Honor. And then they had the lowest hanging fruit you can get as a prosecutor, going to a grand jury without anybody else there, crafting the evidence in any sort of way they wanted to. And thankfully, and it doesn't happen very often anymore, but the grand jury said no. The grand jury said there is not probable cause. Again, the lowest hanging fruit in our system. They couldn't establish probable cause based on this information. And I remembered when this happened, just sort of not even so much representing Mr. Carney, but just as a constitutionalist, as a person interested in the Constitution, as an attorney, I saw this. I read the search warrant, out of the Herald or something, and I was prompted to write this press release that I sent out about this exact issue. And I went back to it, I looked at it again this morning, and it really covers exactly what's going on here. And in that search warrant, Your Honor, it's very clear that the government just wrote a 30-page short story about its efforts to try to find and isolate, and you have it in there, right, to find and isolate communications. And the government wants to criminalize communications. And if you look at my press release, and I'll submit it, or I'm just going to read a few things from it, we have in this Commonwealth a very special provision in our own Constitution that Ms. Reed has the right to present all proofs. And she has the right to fight any way she wants and talk to anyone she wants and communicate with anyone she wants and say, hey, don't share this. Hey, keep this between us. That's her right, her constitutional right under the Massachusetts Declaration of Rights to present all proofs. So when the government cites that just as a bare proposition, she tried to keep this secret. She communicated with Aiden Carney. Then we're going to make this gargantuan leap that she's sharing the intent to intimidate witnesses. So the whole thing is completely bereft of any evidentiary value, Your Honor. Just the notions that they put in the search warrant, and ultimately the fact that they tried to use it to get an indictment and fail. So that's why this has no evidentiary value. The relevancy is zero because they can't put it into evidence. And then further, Judge, as a practical matter, I looked at the docket. I spoke with counsel from the Reed matter. It's my understanding, and everyone's here and they can correct me if I'm wrong. The government agreed to not put anything in their case in chief relative to this issue about communicating with Mr. Carney and consciousness of guilt unless it was, quote unquote, the door was open, which of course is sort of a proposition that's out in the ether, and that ain't ever going to happen in this case, Your Honor. And so that adds to the issue of whether this is evidentiary or not. The government's already backed off. The government got a search warrant filled with nothing but investigative pronouncements. We took a trip to California. We talked to this lady, and they were communicating. All they say is they were communicating. They don't say, "Hey, let's really get that person and let's get them off of this and let's try to have that person not testify. Let's scare that person. Let's harass that person." There's no communications like that. They just have the fact of communications, and that's not evidentiary. That's not relevant. So, Judge, here they just want to get in Mr. Carney's phones. We're not concerned about what's in Mr. Carney's phones. We're concerned about their bizarre interpretation of the witness intimidation statute that they will try to graft onto any communications in my client's phone, Your Honor.
Love it.
So
love it.
There's a few more complicated things, Judge. I feel like you have it, but I just want the court to be aware, having come into this case at this point, there's a pending motion to dismiss with Judge Doolin, basically saying that all these witness intimidation allegations don't cut it under the Constitution, under the First Amendment. So that's pending, number one. Number two, Judge, is this taint team issue. Counsel's doesn't have it right. Went to say that, these first two phones, we already got into them. So the taint team covers everything, all of Mr. Carney's phones. So the fact that the state police snuck in and forged ahead and searched some phones before the taint team could get set up should not inure to the benefit of this Commonwealth. And this is a firewall type of a case with respect to a special prosecutor on the one side and the Norfolk County DA's office on the other side. A Rule 17 motion is absolutely required here, Your Honor. That's the whole point of keeping this confidential and separate. So the Rule 17 territory is entirely appropriate, Your Honor. In terms of
Counsel, what's the legal import of the pending motion to dismiss?
Sure.
And so in this case, how does that change either relevancy analysis or the evidentiary value analysis in this case that I must make in the Rule 17 context?
Sure. So we expect Judge Doolin to come back with a decision that says all of these communications, maybe they're distasteful, maybe they're obnoxious, maybe we don't like them, they're all protected by the First Amendment. So let's look at the search warrant. They're looking for communications between Ms. Reed and Mr. Carney. They don't even have that much. They don't have quotes. They don't have communications. They just have the idea that, they communicated. The fact that they communicated cannot be a basis for a criminal investigation, and it's the extraordinary step of getting into the phones. A couple of quotes on the cell phones, Judge, just to set the context. This is from Commonwealth versus Onyx White. That is a landmark case that involves the notion, and the government is always pushing the envelope, Your Honor. That case was very dangerous. The government was trying to set up a state of the law where just because we all have cell phones in our back pocket, in almost every case, let's see in that cell phone whether they communicated about a crime.
Yes,
and it would have been an unbelievable expansion of government power to search people's private information. Thankfully, the SJC said, no, you need to have a nexus between the phone and the crime.
Yes.
And they cited some other cases in terms of quotes about cell phones. Just two quick quotes, Your Honor. The cell phone is a repository of just about everything that is materially important to a possessor. Documents, messages, emails, notes, thoughts, communications, photos, loved ones, information involving loved ones. The court should not view lightly what the Commonwealth is seeking here. Cell searches would typically expose to the government far more than the most exhaustive search of a home.
This is
So-
yes.
I appreciate that, counsel, but at the same time, the phone has been searched. The data has been obtained by the Norfolk District
should have
Attorney's
never.
Office. It's in it's in 88 Special 88 Cosgrove's possession, custody, control. It's already been seized. 88 Brennan is looking now, it seems, for a very narrow subset of that information that does not contain the long list of materials that you just rattled off from the Onyx White case.
But it never should have happened. The search never should have
That
happened.
issue isn't before me, counsel. That issue isn't before me. The issue before me is
Well,
what
because of
is
that
it
wrong, though, we're
relevant?
here.
Right. What do they have? What do they have to set that up? They have the fact that they spoke. And the fact that they spoke is not evidentiary. It's not relevant. If the fact that they spoke was the basis, we'd be at Onyx White. We'd have the wrong decision in Onyx White, Your Honor, that just because people speak, the government gets to ferret around in their phones. It's a horrifying concept, Your Honor. That's really the crux of why I'm here. And the last thing I'll say, Judge, is that the fact that they got around the taint team we shouldn't just forget about the taint team. These phones need to go back through the taint team if they want to look at them.
Yes.
And on the taint team issue, there's more litigation to be done where the court already allowed scrutiny of the phones by a taint team for attorney-client privilege information. And my client at the time had many civil and other cases going on at the time. So Attorney Cosgrove's statement, there's no attorney-client privileged information in the phone is ridiculous. There's a ton of it. We're also asking right now, Your Honor, for the taint team to scrutinize the phones for, we're going to ask for husband-wife communication.
Counsel, you're not asking.
No, not you. Just so you know what's out there. I just want you to know what's out there.
I understand.
We're asking for husband-wife communications. We're asking for that journalist source materials, of which there's a plethora. We're asking that those be scrutinized by the taint team and all that stuff be taken out. So the taint team issues are still in flux. You know, the fact that they did this, the court should deny this, Judge, just on the fact that this is an 11th hour request. If you look at Lampron, it talks all about undue delay. They had this back in February of 24, and here we are now on the eve of trial on their case. So for all these reasons, Judge, we object. This is a gross invasion of privacy. It's a fishing expedition. There is no hook that they have to say, we will find something criminal in those phones. Thank you, Your Honor.
Thank you, counsel. So, ADA Brennan, before I hear from you any further in response, I am going to hear from counsel for the defendant in this case.
It's going to be Attorney Elizabeth Williams, Your Honor.
Thank you, Your Honor. Elizabeth Little appearing on behalf of Ms. Reed. First, I just wanted to thank Your Honor for allowing us to be present and to be heard on this issue.
Woo, little baby, come on.
The defense joins in Mr. Bradel's request in opposition to this Rule 17 motion. There's just two very brief points that I wanted to address that I don't believe were addressed by Attorney Cosgrove. Your Honor, if you take a look, Attorney Bradel, apologies, Your Honor.
It's a lot of
There are. Your Honor, the Commonwealth's affidavit in support of the Rule 17 is facially deficient as to both elements 3 and 4 of Lampron. The Commonwealth does not include a single fact in the affidavit to show that it cannot properly prepare for trial without the production of this evidence. So just on that basis alone, the Rule 17 is deficient. That's the same with regard to element 4. If the court looks closely at the affidavit that was filed in support of the Rule 17 motion, the Commonwealth is required to show that this is not a fishing expedition. The Commonwealth, again, does not set forth a single fact or even a conclusory allegation as to element 4. And that's because the Commonwealth knows full well that a grand jury has already rejected the Commonwealth's claims that Ms. Reed was somehow engaged in witness intimidation with Mr. Kearney. And on that basis, because it's facially deficient, this has to be denied. We therefore respectfully request that the court deny this Rule 17 motion.
Thank you, counsel. ADA Brennan, I'll hear from you in response briefly.
I think most importantly, the parties are conflating two issues. Whether there is probable cause or beyond a reasonable doubt to convict a person of intimidation of witness and the relevance to consciousness of guilt. It's two separate assessments. It is true there was a no bill, and it is true that there is litigation in Mr. Kearney's case, but these phones are in the possession of the district attorney's office. The information is available. It's been represented. There's no attorney-client privilege. There is nothing to slow down or stop the availability of the information. It is relevant for the judge in Commonwealth v. Reed to assess whether or not this information establishes consciousness of guilt. That is the issue, not the complaints or the concerns or the personal opinions, the constitutional prowess of Mr. Bradle. It is this reflective of consciousness of guilt? And
Hey, Brennan, on that issue, on the consciousness of guilt issue, there was
That's
some
where you're gonna
suggestion, there was
struggle.
an agreement that the Commonwealth was not intending to pursue introduction of evidence concerning that issue unless.
that is not entirely accurate. There was a motion filed by the defense, and they were concerned that when they were cross-examining witnesses in this case, that at the past trial that I was not at, the witnesses then offered to the jury that they were being harassed by social media bloggers, suggesting at the behest of Ms. Reed.
That's
an
not
entirely
true.
separate issue than consciousness of guilt. I agreed that unless the door is opened, a witness should not get up and talk about their state of mind and how they believe they were harassed. I agreed to that because I will instruct the witnesses unless the door is open and you have an invitation, that would be improper. Separately, a consciousness of guilt motion in limine, which I expect to file if it's viable based on the information, is an entirely different proposition.
That's
entirely
false.
different proposition than opening the door to the state of mind. The consciousness of guilt has more to do with the conduct of Ms. Reed. Did she do something that reflects her consciousness of guilt to try to cover for the crimes that she's alleged to have committed? We know she was providing information, even protected information to Mr. Kearney. We know he was publicizing it, appearing at witnesses' homes and addresses. We know that the witnesses, whether it is a conviction on intimidation of witness or not, felt very intimidated. We know the mental anguish they suffered. The defendant, in our case, Ms. Reed, knows it as well, because if you do see the video, with a smile, she acknowledges the consequence of her actions and seems to encourage it impliedly. And
What?
so this evidence should be available to me. I should be able to assess it. I should be able to provide a motion to eliminate to Judge Cannoni if appropriate, and then she should decide the admissibility in the
Bullshit.
Commonwealth Karen Reed trial. Thank you.
Thank you, counsel.
Bradle's
Folks,
so right.
I believe I've heard all I need to hear. I will take this matter under advisement. I appreciate your filings and your oral advocacy today. And
He's
I'll
denying
endeavor to get your response as soon as possible. Thank you.
Thank you.
It's been worn. Yes, and my teenage kids dinner. Yes, exactly. Right. Exactly. So if you want to.
The fuck? This is how crazy long crime is, man. All right, there you have it. You're muted. Thank you. Appreciate that. Okay, so let me just break this all down for you. I think by him cutting them off right there at the end, I believe this is going to get straight up denied. When someone says that they've heard all they need to hear and doesn't give you time, to say anything else, I believe this is denied. The grand jury denied it. What this is from, though, and so this is important for the record for everybody to understand this. This did not come because of Karen Reed speaking out on ID channel. This was filed 10 days ago. So what that tells me is that the only way that it could have anything to do with that production is if a copy was given to the Commonwealth prior to it ever airing, to then say, okay, we're going to file this now. So that's the only way that anybody could say that this had anything to do with that, right? So I understand that this wasn't an emergency motion. For whatever reason, though, it was an emergency to be heard how it was. This was a motion that was in. That's why you got to pay attention to the timeline. Timeline's very, very important. This motion was filed before the ID channel aired that 4-parter. Okay, so I think it's interesting how Brennan, people telling themselves, Brennan says that he didn't watch it, but he has a clip of something. Get the fuck out of here, bro. That's insanity. Okay, when I tell you that I didn't watch it. I saw little clips and pieces due to the fact that I started to watch it when I was going to bed, fell asleep. And then I've had the pleasure of hearing Miss Bella talk about it 24/7 over here. Like in the mix of just saying, blurting something out. I have not watched the 4 episodes. I have heard blurbs about it and saw when Karen Reed was a little girl and saying that, like I said, but to sit here and say that he hasn't seen it and then say, I'm going to play a clip of it, then how would you even have the context of it? You're a lying sack of fucking shit. And this is why my channel does what it does. Stuff like this. He's a professional spinner. Okay, just like that fan. Prosecutors are spinners. And if you're trying to get to the truth, you don't need to spin anything. All right. February 2024 was the search warrant for when all of this should have happened. It is March 2025. That's why you deny this. This is bullshit. Okay. There was a search warrant in February of 2024, and for y'all to be doing this shit right now, that's out of play. Why I got so passionate about what Bradel was talking about, it's the same thing that Cyree was talking about. It's the same thing that Ann Taylor was talking about with our phones. Okay, listen, guys, think about this. If I don't have my phone with me when I go to commit a crime, that's like my house. If I leave my phone at my house, okay? So I leave my phone at my house, or I leave my phone in my buddy's car, right? There's a crime that happens during the time frame that my phone is not with me and it's in my buddy's car who is in another city. How are you going and getting a search warrant for my phone? How are you seizing and searching my phone? It has no nexus to the crime, to the crime scene. How are you going and getting that? Okay? How are you getting a search warrant to search my home? Think about it. Well, because when we dial this all up, it was a bloody scene. So the person would have had to go home and they would have showered and they would have had blood on them. And we could, there's going to be DNA on stuff. There's going to be that bloody outfit. Okay, yeah, that's how they say things. And so they come in your home and they say, we want to look in the bathroom and we want to look at, this clothing. But how do you go from saying that, how do you go and get my phone? How are you obtaining a search warrant for my motherfucking cell phone? Especially if I wasn't on no cell towers. If my cell phone was not there and on any cell towers, how are you going and getting it? Just like when you come into my home with that search warrant, you don't get to go through my files in my office that has all my bills that I pay, my medical shit. You don't get to go through that shit. This is what he was talking about right there. And what he was saying, Breda was saying, is that we shouldn't even be here because what they did then was illegal. God, what the fuck are they doing over there? They need to get their shit together. They need to get their shit together. So this shit fires me up because this is about our constitutional rights. And we have a right to privacy. We have a right to due process. We have a right to First Amendment. for freedom of speech. We have a right to communicate with who we want. We have a right to smile. We have a right to frown. We have certain rights that are not, our rights should not be spun. Okay? If I want to communicate with, if I want to communicate, how about this? If I want to communicate with my pastor, okay, I think that's a sign of guilt. I think that's a guilty conscience that you would have to go and speak to your freaking pastor. Wouldn't that be something like you could, yeah. Why are you going to go to confession? You're going to confess your sins, Lana? Is that what you did? Think about that getting into a court case. This is absurd. This is fucking pissing me off. You know, the first person that Jennifer Drake went and hung out with or talked to was her goddamn pastor. In fact, he was driving behind him, going down to the crime scene allegedly. I mean, bizarre, right? Why would you contact your pastor? Sounds like you got some consciousness of guilt. It's absurd. It's absurd. Versus you can just say, I contacted my pastor because I wanted I wanted the prayers after what I heard. I wanted prayers. You know, I just found out my husband or my boyfriend's dead. I needed to pray. Now that's guilt. Because I could spin that to say, okay, or it sounds like you confess to somebody, your pastor. Paying attention to the timeline of all of this transpiring, they used Turtle Boy and they set up this whole witness intimidation to literally, I don't want to say build a case, okay? But the wording that I would use is to build upon, to add to, okay? February of 2024, that date alone, and coming in here, Hank, you've had all this time. You've been on the case since 2024 in October. What the fuck are you doing? But it's interesting. I will say this, you guys. It's very interesting, and I don't think it's a far leap. I would want to know who produced and who are those people talking to, because I personally now believe that a copy of what was going to air got to the prosecution, and they would have had it, and that's why they filed this motion when they did. Because it's crazy to think that you filed your motion and then voila, this documentary drops, and voila, Hank's over here using it in his oral argument, acting like, I just found out. Bitch, sit down. No way. No way. It looks way more plausible that you got your hands on that production. That's what it looks like to me. And if I was Alan Jackson, if I had some time to blow, they've been just blowing money like crazy. I'd call in these people that did this documentary and ask them point blank, call them up. Did you give this to the Commonwealth prior to it airing? Who had access to this prior to it airing? That's what it looks like to me, is that somebody had access to this prior to it airing. Because I said to myself, come on, man. After it would have come out that there's a gag order, pull this production. Pull this. Hey, there's a gag order. You can't play it. Okay? The defense found out Hank was, no, I know that he, no. Mm-mm. Did you hear Alan Jackson? Listen to what Alan Jackson said to the court. Alan Jackson told the court that we had told Judge Canone 2 days ago, on the last day that they were there, we had told Judge Canone that we had an opposition to this, because that's when this judge just asked, well, I don't even have an opposition from you. You guys didn't even file anything. Oh, no. We told Judge Canone, yes, when we were here, not yesterday, but the day before. Okay, so Alan Jackson knew about this, that this was going to be brought up, maybe not in the fashion that how Hank tried to do it, but I think it's going to get denied. But this was, we got to witness something here, which never hardly happens, right in front of our eyes. Corruption. If this was any other case, guys, think about it. No cameras are around. No one's watching. No one's out tailgating before it happens. If this was any other type of case, this shit happens all the time. These little moves. Prosecutors, I went down to the courthouse a bunch last year to sit there and watch public defenders, all right, meet up with their clients before they had to go into the municipal court. So they're just like shuffling them like in and out. You just have like a list, and it has like, this case versus this person, this case. And I sat there, brought a notebook, and literally watched prosecutors, and this is all open, you can go and sit there, prosecutors and public defenders communicating nonstop, and then these defendants are sitting just outside of it waiting to be called, and having no idea what's going on. All right. Them coming back out, talking about their plea deals, like, hey, this, whatever it may be about, or there's no, it is, you are hurling cattle. Okay. So I was like, well, I'm not a lawyer, but I can most certainly say whatever I want to whoever I want, whenever I want. Okay. So I sat there and I watched these literally public defenders telling these people shit that I'm just like, so I was over there acting like I was sitting on the elevator, and I'm like, hey, you should probably ask your attorney. I said, what are you facing? Yeah, you should probably ask. Yeah, you might want to take this, write these notes down. This is what you need to ask your person. I was like, did you get discovery yet? I was like, where are you at in their case? I was like, what is this for? I was like, you need to start asking a lot more questions. I was like, when is that the first time you met with your public defender? Yeah, I didn't even know who it was. Yeah, okay. I was at one of the guys, and I said, if you take that deal, you're a fucking idiot. And they're like, who are you? I was like, I'm just here observing just our justice system. I was like, I heard your address just because he blurted it out. I was like, that's not that good of an area, is it? This one guy, and I felt so bad for him. And he's like, yeah, but I need to get this over with, because then my baby mama's gonna try to use this against me to take my kid, blah, 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 like all this shit. I was like, yeah, that's why you definitely, I was like, tell me you only take disorderly conduct. And I was like, then you listen to me. The new laws in Ohio passed, you will expunge that shit automatically within a year. Okay. I was like, you tell me the only thing that you're taking is a disorderly conduct, and on it you want X, Y, and Z. Like it was like you were holding up traffic. I was like, that's disorderly conduct. I was like, that's the shit that you will only settle for. Otherwise, you do not take a plea deal, because it'll be used against you. Trust. And this guy was like, who are you? Can I get a business card? I said, no business cards. Listen to me. Write this down, and this is what you need to tell your lawyer. And then make him pay for your lunch next time. Make him pay for your lunch next time. They're just ridiculous. Just ridiculous. I was like, was the cop here that rung you up? No. I said, you want speedy trial now. Go. Oh, here we go. All right, turn up your volume.
Draw near, give your attendance, you shall be heard. God save the Commonwealth of Massachusetts.
This court is now open. You may be seated.
22117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record, starting with the Commonwealth?
Good morning, Your Honor. Barbara Boston for the Commonwealth. Good morning, Mr. Boston.
Avalon for the Commonwealth. Good morning, Your Honor.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alan Jackson for Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. Robert Alessi on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Unetti for Karen Reed.
Good morning, Ms. Yannetti. Good morning, Ms. Reed. All right, so we have a lot to cover this morning, but what I want to start with, I was just handed a couple of things too that I'm going to need some time to read. What I'd like to start with is paper 613 filed yesterday. Defendants assented to motion to continue trial date to a date on or after April 25th. Who's going to argue that? Because just because it's an assented to motion does not mean it's not likely going to happen. So I need to hear argument on why I should do this.
I'll address the court with the court's permission.
Yes.
As I indicated to the court the day before yesterday, there is an issue, a very ripe issue that is currently pending before the First Circuit. We believe very strongly that if the First Circuit were to take some action as to count 1 and count 3, just to reiterate what I've already said, but I can sort of clarify it and narrow it down. If the court were to take some action on counts 1 and 3, which is currently before the First Circuit, for instance, if it were to be remanded for either dismissal or something else, additional hearings, etc., then that puts the entire case in jeopardy. Once the jury ultimately is impaneled and thereafter sworn, jeopardy will attach. There will be, if in fact there is action taken on count 1 and count 3, we will be in a position where we will seek a mistrial. Jeopardy will have attached. She will be held once in jeopardy on count 1, 2, and 3, and we believe that puts the entire case in peril. The case that we're defending right now, very clearly, is a murder case, ultimately, along with
All three indictments, correct? You're defending all three.
But it starts with murder. That's the sun rises and falls on a murder charge. And there's also vehicular manslaughter, and then there's the leaving the scene, count 3, and the subordinate counts beneath count 2 as well. That's a very different jury and a very different trial strategy than simply count 2, if we were to be defending count 2 or it's the subordinate charges. So I think it puts the case in jeopardy if we do not have at least some time for the First Circuit to act and determine whether or not it wishes to act on counts 1 and 3. Hence, that's why I suggested to the court the other day that it might be more prudent and less perilous for the case if we were to put this case over for at least a few weeks. We've spoken to the Commonwealth, and the Commonwealth tends to agree that that probably is the better practice. And we've asked for the court to extend the beginning of the trial to April 25th, which is about a 3.5 week continuance. And I'll submit.
All right, does the Commonwealth want to be heard on this?
This would help out Hank too, for him to get his ducks in a row over there.
Your Honor, the Commonwealth is relying on advice of appellate counsel. I don't contest any of the defense's perspective for wanting continuance. I think the Commonwealth's perspective is different, but not adverse. The concern is that this case in the federal court gets delayed for an extraordinarily long period of time, and we have an interest in this case going to trial as soon as possible. There is an expedited scheduling order, which could hopefully imply that there's going to be quick progress in the federal court, but we don't directly communicate with them or have any control. Our hope is that if there is a short continuance, it accommodates the defense's concerns. I understand the trial strategy for different charges is somewhat different. But most importantly for the Commonwealth, the hope is that it sets a benchmark that will allow the First Circuit to resolve the petition, or if they're going to allow oral argument, a benchmark to do it quickly. And so really the primary motive for agreeing to the defense request is that we hope by offering a short continuance, the federal court will act more quickly and that we can have this trial in April.
Okay. Well, I'm not going to grant the motion. All right. We have jurors coming in that were summoned months ago. I called the jury commissioner yesterday and asked how long it would take to get the right numbers that we were able to get starting April 1st. At a minimum, 10 weeks. I'm not going to do that. What I will do is we'll start impaneling on April 1st. It will likely take a while. If we get a jury before April 25th, I'll rehear you on your motion. We won't swear the jury because obviously that's when jeopardy attaches. And we'll take it from there, but we will start April 1st with impanelment.
Thank you, Your Honor.
Okay.
Oh my
So
God,
let's
I
go to
love
the
it.
next motion, and then we'll go back to doing them somewhat in order.
Yeah.
Commonwealth's motion for a
Anti-Bev,
buffer
not
zone.
disappointing.
Jimmy, do you have an extra copy of what you just handed me? Because I don't
Right there, boom. Staying true.
I have it here.
No disappointment right there. Anti-Bev says, yeah.
So we did hear from people this morning.
This is
I know
awesome.
you all have.
This is so appealable.
I have it, Jim. I think Mr.
What a
McDonald gave you a
fool.
copy of, I guess, what local
She ain't messing up her
merchants
summer for
have
nobody.
requested. Okay. All right, so I'll hear the Commonwealth on your buffer zone motion.
Buffer my ass. Buffer zone, baby. Buffer. Looking buffer
Your Honor,
there.
the Commonwealth's primary concern is the sanctity of the jury and the jury process. We are concerned based on past reports and information that noise, interruption, and other uncontrollable events can potentially impact the jury's consideration in this case. They should be free from outside influence, so it does not in any way oppress or push them in any direction, either way in this case. The courthouse is very close to the public areas where people congregate. It's been reported that during the trial, the jury would be able to hear outside noise and influences, not just honking of horns, but other types of noise that could be influential, intimidating, concerning. And so we've proposed what I think is reasonable and minimal recommendations to the court to move certain parts of the buffer zone, especially on the left side of the courthouse, where there seems to be a bit of attention, noise, and potential adverse influence to the jury.
And that's the same area that these merchants are talking about?
I've read that this morning, not being fully familiar with the Dedham area. It seems that is one of their concerns. I think they mentioned an open market. In my memory from coming by on other cases at other times, there appears to be open markets in that area. And so if that's influencing their business, that is a separate related concern that they have expressed to the court. And I do think that the court should be sensitive to the community's concerns. But
That's
importantly, that closeness and that amount of volume and influence on the jury, I think, can affect the sanctity of the jury.
The people's businesses will be fucked.
Position to consider the streets that have been identified in our buffer zone motion and have the buffer zone include limitations to those certain streets. And I think that will potentially help some of the outside impact and adverse influence on the jury.
All right. There's a portion of your motion that I disagree with. Do you want to be heard on it? About the court enforcing or enforcing buffer zone?
I don't believe the court has authority, nor should it be upon the court to enforce anything. I think law enforcement should enforce the laws and regulations as law enforcement sees fit.
How do you
So I don't think that burden should be imposed upon the court.
Thank you.
Then why did you put that in there, you fucking dipshit?
Does the defense object to the buffer zone?
Yeah.
Okay.
We take no position.
Right. I'll take this under advisement. I have to figure out exactly
Love it.
how far this is. And I have not yet had a chance to read and consider
This is amazing.
today's email from the merchants.
Yes, the merchants got involved. I love it. You guys know what that means, right?
Yes.
Hold on really quick. I want to tell you guys what that means. That means back in the day, I used to own a bar. And if you're going to sit here and tell me that you're going to cut off access, all right, people can't come into my place. All right, how do I make money? Get the fuck out of here. We're not closing down these streets. No way. Pay my rent. Pay my bills, bitch.
Can I just have this marked for identification for this hearing, identification? And from the record, that came from the Dedham Square Circle, the organization that runs the Dedham Farmers Market.
Thank you. So we can talk about the witness list when we talk about impanelment, when we really have the heart of the final trial conference. But I do need at least cities and towns from these witnesses. Neither side gave them to me on the civilian witnesses. So, and there's a lot of overlap, and you'll have to fix that for any final trial conference report.
Look at that gem, guys. Look at her. Give it up for Bev. God. I bet you she's a cool ass grandma. You know? She don't give a shit. This gets the cape. I'm gonna get this in and out. They told me it was 6 weeks. I got Alan Jackson for maybe another shit. Brennan says he's only gonna go 3 weeks. I could be ready to go on the woo-wee.
Report anyways. All right.
Bev shut down the farmers market.
Your Honor, could I be heard on that one issue, just briefly?
Which one issue? The witness list, okay?
Yes, we did turn over our witness list along with the information that's required under the new rules, which includes, telephone numbers, addresses. We gave that directly to the Commonwealth. We did not file that publicly.
Okay.
We'll happily add the towns for the court. But I would note that the Commonwealth has not yet turned over that information that's required under the new rules. I believe they put a footnote on their witness list. I think, they can't shield themselves from their discovery obligations. It's mandatory under the rules. We'd ask that they comply with, the requirement that they provide us contact information for their witnesses.
So there is a footnote. I'll hear you, Mr. Brennan.
Your Honor, the motion notes that the Commonwealth moves to be partially exempt from Rule 14 because of the past history of perceived harassment and intimidation of witnesses, which the Commonwealth believes is ongoing. I think a potential resolution to this to comply with Rule 14 is that we be allowed to provide it to the attorneys under seal. I think that is protecting the interests of the Commonwealth and the witnesses from...
I don't have a problem with that. I still need cities and towns.
Of course.
Okay?
Yes.
Okay.
All right. Thank you. So we will start with it's paper 593. The Commonwealth's response is paper 610. Defendant's motion eliminate to allow evidence of lack of bias.
Okay.
Who's arguing that for the Commonwealth?
The Commonwealth first, Your Honor.
Oh, it's defendant's motion. And the Commonwealth opposed it.
You had asked who's arguing that for the Commonwealth. That's why
I'm sorry, defense motion. Okay,
that's fine.
sorry, I apologize.
I could go first if you'd like.
Excuse me?
I could go first if you'd like, whatever.
I'm fine with him going first if you'd like.
Okay.
I'm fine with him going first. All right. 610. Let's get on my 610.
I think the heart of this motion is that the defense would like to introduce the ARCA witnesses as witnesses that were employed by the federal government. I think the reason for that is it creates the image or the projection that they are independent at the time they did their assessment and at the time they wrote the report. And then subsequently being employed by the defense has no impact on their objectivity at the time they did their investigation and report. I think this would be an unfair proposition for a number of reasons. It would undermine Rule 403. It would cause a trial within a trial. As we stand here today, the Commonwealth does not have a clear answer why this investigation was initiated, what the purpose of it truly was, the scope of it. We don't know every witness that may have gone before the grand jury. We do not know of all the communications between the federal government and different parties, including witnesses. We will, I expect, never have truly a full accounting of the relationship between the United States Attorney's Office and ARCA, and what, if any, impact the defense had on ARCA witnesses at the time they did the investigation. What we know is it was a comprehensive investigation. We know that a number of experts were retained by the federal government, including the ARCA witnesses. What we also know is that there was an inquiry lodged by the defendant to the federal government to investigate her situation, her case. What we know is that the defense had the opportunity to provide information to the federal government advocating for their perspective on the case, including the specific perspective of Ms. Reed. We also know the Commonwealth was unaware of this initiation and engagement and had no input whatsoever. What we know is that the ARCA witnesses were supposedly tasked to conduct an independent investigation, and they were given materials. We do not know who decided what materials to give them. We do not know what materials in totality they viewed. We know many of the materials that they weren't given. And so clearly there is an undefined relationship between the defense and the United States Attorney's Office around this time of this investigation. And we subsequently learned that there was a continued relationship. And so today, as we sit here, we really don't know. What we know is ARCA listed materials that they reviewed that came from our discovery that we didn't provide. What we know is there was materials that they didn't review that were inculpatory. And so that's why we began by asking for discovery. We filed an extensive motion for discovery that the court allowed. It still hasn't been complied with. Perhaps some of it through no fault of the defense, because I don't think they will be able to comply with much of it. Other Rule 14 discovery obligations have not been complied with. We've received no information since that production on February 13th, nothing. And we know.
This is Tina with What the Fuck Transition Services. What the fuck are you talking about, Brennan? What are you talking about?
It would be misleading to have ARCA witnesses get on the stand and then suggest that they were independently hired by the federal government and all of their attempts and efforts in report was wholly and entirely objective. Just to give one point that emphasizes the concern, the ARCA witnesses were never given information about DNA. And yet when they testified, one of the witnesses tried to address the issue of DNA because it was hurtful to their position. In their report, they say one of the reasons why they believe that there was no impact between the car and Mr. O'Keefe is because there was no DNA. Well, in fact, there was. There was DNA, and separately there was a hair, Mr. O'Keefe's hair. And so we know they didn't have all of the inculpatory information, and then the question still remains, how did they learn of that? How did they learn of that information before cross-examination? And so I think what is most appropriate before Your Honor makes a decision on the so-called objectivity of these witnesses is they should come into court before trial, well before trial, and they should answer questions about their directives from the United States Attorney's Office. They should answer questions about the materials they received. They should answer questions about what they were told or what they knew about the case. They should answer questions about all of their correspondence with the defense, including phone calls, emails, text messages. All that should be produced. It's not a litigant hearing where I question their qualifications, but if we're truly going to think about presenting them as objective witnesses, they truly should be objective. And I think if we have an opportunity to question these witnesses, we will learn much more about the relationship. Inevitably, even if the ARCA witnesses come in to be questioned as they should well before trial, in my opinion. We do not have the opportunity to question the United States Attorney's Office. We're resigned to TUI letters, which inevitably have been unhelpful. And so I think it sets a bad playing ground to have them get up and say they were hired by the federal government, because then the Commonwealth will be inclined to explain the inculpatory evidence, the role of the federal government, the limitations of the federal government, the fact that the federal government has closed this entire case and all related investigations, which implies something quite the opposite of what the defense would like to propose. And so in a vacuum, it would be misleading. I think what the court ultimately should do is they should present these witnesses as they did at the first trial. They were hired independently. And then subsequent to that, the defense retain them if that's what they chose to do. We still don't know that because we don't have any Rule 14 discovery. And inevitably at trial, part of the credibility issue will be the information that they considered and the limitations on it, and ask them why they didn't ask for more information or why they didn't receive more information. Notably, we still don't have an answer to Mr. Klein, who was the third biomechanic person involved. And
Is his name on the witness list?
I haven't seen it on the witness list.
No, Your Honor.
And we still don't know why the defense chose to call 2 of 3. As you noted, that report is vague. And so it doesn't identify or articulate which witness did what. So it's impossible for me to imagine how you would choose 2 of 3 of those witnesses. But more importantly, you can't effectively cross-examine a witness because, as we saw from the second witness, Dr. Rentschler, when he disputed DNA, which we don't know where the source of that came from, he is not held to the opinion in the report saying that we would have found DNA. He can simply defer and say that was somebody else. That could have been Mr. Klein, could have been Mr. Wolf. We don't know. So that report really is quite unhelpful. And I think we need answers to these questions before any of these witnesses testify. And I do not want to be moving during trial to exclude the defense witnesses for failure to comply, but we haven't seen compliance, and I don't think we will. So my suggestion is to follow the protocol of the last trial, but before that, these witnesses should be brought in so that we can obtain actual records, not just ask them the questions and rely on their word. I think based on their past performances, that's insufficient. I think we should have a right to the records to demonstrate the relationship.
Mr. Yannetti?
Thank you, Your Honor. Your Honor, the Commonwealth and the defense certainly have opposite arguments when it comes to what the jury should be allowed to hear about how the ARPA witnesses became involved in this case. Mr. Brennan speaks about the heart of our motion. The heart of our motion is that the Commonwealth wants to hide the truth from the jury. The defense wants the jury to know the truth. In the first trial, this court disallowed the ARPA witnesses from testifying about who hired them. We were therefore forced to ask oblique questions, trying to show the jury that we didn't hire them, that we didn't provide them with information, that we didn't influence their opinions and conclusions. But we weren't allowed to tell the jury that the Department of Justice, the U.S. Attorney's Office, hired them. So the jury was left to speculate about how they became involved. I think the court will agree that it's ironic in a way that the court excluded mention of the Department of Justice and the U.S. Attorney's Office because the court rightly did not want the jury to speculate about a federal investigation. But by excluding mention of the jury was left to speculate incorrectly about how they became involved.
They were also instructed more than once not to speculate, right?
But the point of the fact of the matter is
they did
speculate. At least one juror thought that ARCA was hired by Ms. Reed's car insurance or home insurance and think about the implications of that. If Ms. Reed's insurance company had hired ARCA, they would have had a motive to absolve Ms. Reed of responsibility. That clearly would have adversely affected their credibility in the eyes of the jury, and unfairly so.
Let me ask you a question. If I allow, and I'd be very surprised if I did, mention that this was a federal grand jury and that the federal, How does that not open the door to all the testimony that Mr. Brennan just brought up that he'd be able to get into?
Okay, so first of all, and this is later in my argument, we're not asking.
So, no, could you answer that now, and then I'll let
I'm
you say
trying to,
everything.
Your Honor.
Oh, you just said it's late. Hold on. You just said it's later in the
I
argument.
know, but I said you interrupted me, and I was just about to say that I'll address it now.
Okay.
We are not asking that the jury be
Look at Turtle
told
Boy.
that there is or ever was a federal investigation.
Is that right?
That phrase, federal investigation, never has to be part of this trial. We're only asking that they be told that the Department of Justice or the U.S. Attorney's Office hired these witnesses. That's it. We don't have to speculate about an investigation, whether there was an investigation, whether there was a federal grand jury, what that grand jury did, what that grand jury considered, nothing. That's not what we're asking. And the problem here is that without knowing that the Department of Justice or the U.S. Attorney's Office retained ARCA, the jury's left to speculate about how they became involved in it.
Get at it with the right hand. Whoosh.
It's a prejudice, my
Sit
client.
down, Bev.
Thinking that they were potentially hired by an insurance company of Ms. Reed really perverts the truth in this case. It's unfair to my client, and it's the opposite of the truth. There was another juror that speculated that the ARCA witnesses were just attention seekers, looking to make a name for themselves in a high-profile case. That's also the furthest thing from the truth. They had never heard of this case before the Department of Justice called them. That's how the Department of Justice wanted it. They wanted clean experts who would take a sober and strictly scientific look at the evidence. The federal prosecutors did not want them to be tainted by news reports or opinion pieces. And recall that the Commonwealth attacked ARCA on cross-examination for the discovery that they were not provided. That was patently unfair. ARCA should have been allowed to explain why they were given what they were given and who gave it to them. The inference is, and the Commonwealth suggested, that it was the defense that was playing hide the ball, when that inference is, again, the furthest thing from the truth. In terms of the information that the federal government got, Mr. Brennan engages in a ton of speculation about what happened or didn't happen based on nothing. There's no affidavit to establish any of that. I will tell the court that I received a subpoena for my entire file from the federal government, and I complied with that subpoena. We had nothing to hide. We provided everything that the Commonwealth provided to us, to the federal government. They chose what to give ARCA or what not to give ARCA. And they did that again to preserve the scientific integrity of their opinion. So, again, we're just asking that ARCA should be allowed to testify that they were hired by the federal government to prevent speculation about who hired them or why they became involved in the case. If the issue is we don't want the jury to speculate, the way to do that is to tell them the truth. We did not hire them. We did not influence their opinions. We didn't even know that they existed until that TUI request was complied with. And all of a sudden it was revealed to us that the federal government had hired these ARCA witnesses. And we read that information at the very same time that the Commonwealth read that information. Those witnesses, importantly, were available to be called by both sides. The Commonwealth chose not to speak to them. The Commonwealth chose not to contact them because the information was exculpatory. The jury should not be left with the impression that Karen Reed or the defense team had anything to do with hiring them or with their conclusions and opinions. The conclusions and opinions were revealed to us at the same time, and the court should guard against rank speculation. Mr. Brennan's other arguments about what they were provided or what the relationship was or what the understanding was, that's all cross-examination material. He's free to explore whatever he wants on cross-examination. So with that, Your Honor, we would ask the court to issue a ruling that does not mislead the jury about how ARCA came into the case.
Yeah.
Any follow-up?
Yes.
Fodder for cross-examination, exactly.
Respectfully, the Commonwealth does not look to hide the truth. The reality is, if the jury is going to hear information, they should hear the entire truth, not a version or a slice of it, not one advocate side of the truth, the whole truth.
Okay.
And
nothing
if
but the
we
truth.
interject that these witnesses were hired by the federal government and the jury's entitled to hear the whole truth, then they should know the motivations behind the hiring, the input from the defense team prior to their decisions, and what, if anything, they considered and what their directive was. We don't have any materials from the federal government regarding direction, scope, purpose. We have nothing. Now, I didn't know that Attorney Yannetti's file was subpoenaed. That's new to me. Perhaps the Commonwealth knew. I've never heard that before. I don't know how the defense knows what the federal prosecutors wanted. They've never discussed that with us. We don't have that type of relationship.
Why would they
with
discuss
the federal
that with
prosecution
you?
in this case or their investigation?
It's not
We
your
didn't have any
concern.
interaction, not because we chose to hide from exculpatory evidence, so we were hiding from the truth. We weren't invited. We didn't know.
Invited?
Now,
Say T.
I hear now that Mr. Yannetti's file was subpoenaed and information, whatever it was, his entire file was given to the federal government and they chose whatever they chose. This report by ARCA was produced by letter February 12, 2024. We know from at least some of the materials we got, there's a document from Attorney Yannetti on March 29, 2023, describing his client's best memories of events, a number of pages talking about the case. So there clearly is a relationship that we are not privy to. I'm not casting aspersions or trying to suggest there was anything improper about the relationship. I'm not suggesting that, but there was obviously a relationship between the parties that the Commonwealth was not involved in. And so we can't take a fraction of something and say we present them as independent witnesses when there was a purpose, there was an agenda, and it wasn't in the Commonwealth's interest, obviously. The ability to cross-examine a witness is only as good as the evidence and information you have. As you've seen from the ARCA witnesses, from my opinion, my perspective, respectfully, is when they answered questions, perhaps it was not perjury, but it was quite misleading, suggesting no relationship with the defense, talking about DNA with no DNA evidence. I do not think that cross-examining a witness, you should consider the witness a trustworthy guide unless they've established their credibility. I don't see that in these transcripts. So I will need materials to hold them in check and to hold them accountable for whatever it is their bias. And so simply cross-examining aimlessly is totally ineffective. It's a recipe for disaster, and that's not the type of examination we're going to engage in. If we're going to tell the whole truth, it has to be the whole truth. And I think that becomes a dangerous game. There'll be an entire trial trying to advocate influence or no undue influence with these witnesses. It's unnecessary. It can be resolved through questioning these witnesses prior to trial and following the same protocol you did last week.
All right.
Get your pencil.
So if the defense intends to call the ARCA witnesses, we need to have a voir dire next week. All right.
What? Next week?
We're going to move on. I'll take this under advisement.
Can I just ask the parameters of that voir dire, the purpose of that voir dire?
Unless Rule 14 is complied with, it will be for the Rule 14 information. We can discuss this later. Let's move on, and I'll hear any
Discuss this
objections
later. When? All right. Rule 14. Where's the motion?
All right. So
What
the
Rule
next
14?
motion is the defendant's motion.
She just made up a motion?
It's for objections. I'll hear you on that, Mr. Yannetti.
Yes, I believe my written submission essentially makes the argument, Judge, but
Okay.
During the last trial, as a result of our inability to state in one or two words the basis for an objection, we had to go to sidebar far more often than we'd like to. And we're also conscious of the fact that, we have a jury sitting for weeks at a time away from their families, away from their jobs, and any, sort of view that one side may be delaying the trial could engender some hostility from the jury. So, there were many times during the trial, I won't speak for my co-counsel, I'll speak for myself, where an objection was made. I had no idea what the basis of the objection was. And the court made a ruling on that objection, and I had no idea what the court's basis for the ruling was. We would go to sidebar, and the first thing the court would ask the Commonwealth was, what's the basis for your objection?
To make a record at that point.
Oh, I understand, but it's, what's the basis for your objection? If it were that obvious that it could be ruled in open court, we should have known the basis for the objection. I didn't know it.
I agree with that.
And
You should have known the basis for the objection.
Well, I'm hearing it for the first time at sidebar. There were objections made that I thought had no basis in the law or evidentiary rules whatsoever. But in any case, this will avoid us having to go to sidebar multiple times. There were times when we had to sort of pick and choose when we went to sidebar because, again, we didn't want to engender hostility from the jury. My motion also points out, Your Honor, there's at least one case that talks about how an objection could be potentially waived if it is not stated with particularity. We think that this would, and look, different judges have different opinions regarding this. I've been in front of plenty of judges over my career who endorse speaking objections as long as there's no, trying to coach a witness or, trying to influence a witness in any way. And that's not what we're seeking to do here. The objection hearsay, the objection lack of foundation, just standard basic objections. There's no prejudice to stating them in open court. It will move the trial along more quickly. It'll allow my client to preserve her due process rights, and we'd ask the court to change its ruling from the first trial.
Okay, that motion is denied. So the next motion, defendant's motion, eliminate to exclude false and irrelevant statements of Michael Proctor, 591. Does the Commonwealth intend to put this evidence into the case?
We do not.
Okay.
So we can agree to that motion.
All right, so that motion's allowed, Ms. Giannetti.
Ooh, 10-3.
There's a defendant's motion for reconsideration of the March 6th court order denying defendant's motion to exclude witness Crosby. Mr. Lessie, what I'm going to do with that is if I can readdress that before rebuttal, before the witness is called. So we don't need to do this now. We'll wait and see what Dr. Russell's testimony is and if the Commonwealth's going to call the witness. All right, so we can
Can you
address it
call the
later.
farmer's market
Thank you, Your Honor.
in
And
Dedham
also just
and
want to
ask them
clear
for the
on
letter
that,
they
and
sent
to
to
the
court?
extent we argue for the need for a voir dire, would that also be part of Your Honor's consideration?
So if I feel I need to reconsider it, that's the time to do it, after Dr. Russell's testimony. All right, there's a motion, it's 599. Defendant's motion, eliminate to prohibit the Norfolk District Attorney and Massachusetts State Police from having juror contact. So we don't need to belabor this. We talked about this before. No one has contact with the jurors other than the court officers. So defendant's motion, eliminate to prohibit Norfolk DA and Massachusetts State Police from having juror contact. I'll also include prohibiting defense counsel and the media as well. No one is to have contact with the jurors. The court officers are the only ones that have ever had contact with the jurors. So there's that. So I think now we move on to something that may take a little bit more time.
Okay, take your.
The defendant's motion, eliminate to exclude the testimony of Dr. Judson Welcher. How do you pronounce his name, Mr. Brennan? Welcher, and the Commonwealth's opposition. So who's arguing for the defendant and how long do you think this might take? Because we can do some of the quicker Commonwealth motions if you want.
I am going to make the argument, Your Honor, and I estimate 40 to 45 minutes for this motion.
Okay. Mr. Brennan, how long do you think you'll take?
It's really dependent on what Mr. Alisi says, but I can't imagine it's more than 15 minutes, perhaps 10.
Yeah, that's 2019.
All right.
That's it, but I just want
Before we
number
go there, there were a
recently.
couple of the Commonwealth's motions that seemed pretty quick. That I just wanted to know if the defense had objections to. To appoint a stenographer, we've already done that. Prevent identification of jurors and impound the juror names during trial. Why don't we do a few of these, then we'll take the recess around 11, and then we'll come back with the lengthier motion. So I'll hear you on this, Mr. Brennan.
Thank you. Which motion, Your Honor?
It's your number 1, 575. Commonwealth's motion eliminate to appoint court stenographer, prevent identification of jurors, and impound juror names during trial.
Commonwealth believes appointing a stenographer is a prudent practice.
What number?
We've already done that.
Okay. Preventing identification of jurors. This case is a case that has garnered extraordinary public interest. There are some concerns that in the history of this case, jurors have been identified by different characteristics, whether it's their hair color, their profession, and inevitably, as the trial progresses, it seems through sometimes the media, the jurors, although maybe not identified by name, have some of those characteristics promoted. That would cause, I would think, a strong concern by a juror that their verdict could be disfavored by one side or the other. That's the last thing I think anybody in the courtroom would want. And so the jurors, I suggest, should not be identified before, during a panel, and during the trial. I think the jurors' names should be impounded. There has been past efforts by many to identify jurors, interview jurors, get information about jurors that is then highly publicized. That will chill, I think, the process of deliberation in a fair trial for both sides. I think it is a measure that is accepted, it's appropriate, and under the circumstances of this case, I ask the court to do that.
All right. Any objection from the defense?
Your Honor, we have no objection to appointing a court stenographer, impounding jurors' names and information, and in fact, we join in that request.
Okay.
The motion, however, also asks for the impoundment of all sidebar discussions. Before I address that, I guess I would first ask whether Mr. Brennan is pursuing that part of the motion.
I think that's a good question. Sidebar discussions regarding jurors?
Oh, well, if it's sidebar discussions regarding jurors, we're in complete agreement.
So sidebars are impounded regarding jurors anyway.
Right. So we're in agreement with that. I interpreted the motion, perhaps incorrectly, that Mr. Brennan was seeking the impoundment of all sidebar discussions regarding all issues.
It sounds like he is because of the fact of people listening to FTR.
Okay, well, that's what I'd like to address.
All right, so I'll hear you on that.
Thank you. So we do question the impoundment of all sidebar discussions.
Okay, you agreed to it last time, right? So this is a change.
This is a new trial, Judge.
Right, no, so just to be clear, this is a change.
I don't recall what we did or didn't do last time, but this is our position for this
Okay.
trial. Obviously, the reason some discussions are held at sidebar is to prevent jurors from hearing legal arguments on the admissibility of evidence. But this is otherwise a public courtroom. The public typically has a First Amendment right to know in Massachusetts what is going on in a public courtroom. And in fact, in Massachusetts, it's not just a First Amendment right, there's also a common law right to know what's going on in the courtrooms. And when justice is open to the public, it serves as a check and balance to the conduct of the parties and of the court. Consonant with these policies, in one of your recent rulings, Your Honor, the court recently cited to the strong presumption of Massachusetts law that a courtroom be open to the public. Therefore, there's both a state policy and a benefit to public disclosure of courtroom discussions and rulings. Of course, if there's something that is discussed at sidebar that involves information subject to a protective order, portions of sidebars can be impounded. If there's some other reason for a sidebar conference to be impounded, the courts can so rule at the time. But a prophylactic blanket impoundment covering all arguments made at sidebar would sweep too broadly over these important rights and policies. There's a lot of publicly available information about this case already in the public domain. There are commentators who write and speak about this case every day on the internet. Sidebar discussions become yet another source of information, but the court's able to guard against the jury being influenced by extraneous information outside the courtroom by instructing them every day, as you did during the first trial, that they're not to read or watch or pay attention to anything about this case outside the courtroom. And in that sense, sidebar discussions are no different than the daily news about this case that is discussed incessantly. And for that reason, we believe they should be generally made public.
All right. So last time they were sealed, and that was by agreement of all the parties. So this time there's an objection. What is the authority for me sealing or impounding sidebars?
I don't have an answer to that. It's something I'll need to look into because it is a legitimate concern of the Commonwealth, but there needs to be authority. And I can't say right now I have authority for it. I can tell you the concern is that many of the sidebars help vet out information that should not be heard by the jury. It's not the community that's the concern. Even the most diligent of juror in a trial of this magnitude and this length may hear extraneous information, whether they're looking at news reports or not, whether they're simply getting lunch. If there's evidence that is deemed inadmissible and prejudicial to the jury, there runs a real risk if the public hears the promotion of sidebar conferences. It's not an attempt to stifle First Amendment. It's not an attempt to deprive the community of the full value of the public trial. Rather, it is the concern that this case, unlike most or any, seems to have a political event component to it, and factions and sides and heavy promotion. It's a cottage industry in ways, unfortunately. And that creates an enormous amount of social media and media attention, which I embrace for the First Amendment, but we want to keep the jurors from hearing information that would be prejudicial or extraneous. And given the length of the trial and the heavy scrutiny in social media, that's the government's concern. But I agree the government should have a legal basis. If you'd give me an opportunity, we can offer the court whether we have that basis or not, but I can't tell you that now.
All right. So I am taking a lot of these motions under advisement. I'll give you until tomorrow afternoon.
Thank you very much.
Is there an objection to, it's 577, it's the Commonwealth's Exhibit 3, Motion 3, Commonwealth's motion for in-court identification. Is there any objection to that?
No objection.
All right, so that's allowed, Mr. Clerk. And the next one, Commonwealth's motion eliminate to admit the victim, one photograph of the victim, 2 photographs of the victim's injuries as observed by medical providers during the autopsy. Is there an objection to that, Ms. Little? That's allowed. 578.
Thank you.
So the manner of death, so that is on the death certificate. So this is your number 5, Mr. Brennan. Paper 579, Commonwealth's motion eliminate to preclude reference to and redact the manner of death contained on the victim's death certificate. I'll hear you on that. Yes.
Pursuant to Mass case law, Commonwealth versus Almonte and Wallace, as we've laid out in our memorandum, we would like to have the cause of death redacted from the certificate. Certainly, the defense can cross-examine any witnesses that are called regarding the manner of death, but this notation on the death certificate is extraneous and it should be inadmissible. General Laws, Chapter 46, Section 19, provides nothing contained in the record of a death which is reference to the question of liability for causing the death shall be admissible in evidence. Again, different when questioning a witness that is offering an opinion regarding the cause of death, but the certificate itself should be redacted, and it should follow Massachusetts general laws, and it should follow Massachusetts case law. For those reasons, we ask the court to redact any cause of death in the death certificate itself.
All right, who's arguing this for your defense? Ms. Little?
Thank you, Your Honor. In this case, the medical examiner who completed the death certificate concluded that the manner of death was undetermined. The Commonwealth is seeking to exclude this information from the death certificate because it is exculpatory. The Commonwealth seeks not only to have the court redact the manner of death here, but they're also not calling the medical examiner in this case, which creates certain issues. All of the cases cited by the Commonwealth in this matter deal with the issue of whether it was error for the Commonwealth to admit a death certificate listing the manner of death without redacting the word homicide, because it violates a defendant's constitutional right under the 5th and 14th Amendments to the United States Constitution. That is not the situation that we're presented with here. None of the cases cited by the Commonwealth that were just referenced by Attorney Brennan stand for the proposition that a death certificate listing the cause of death as undetermined should be redacted. If the court looks closely at even the cases cited by the Commonwealth, specifically Commonwealth versus Ellis, I'd urge the court to carefully read that opinion, because what it says is that the SJC identified the words that best practice dictates should be redacted from a death certificate. And what the SJC said is this, and this is dicta, it's not even true case law. The better and safer course is to exclude from a death certificate the words homicide, suicide, or accident in a criminal trial. Notably missing from that is the word undetermined. And that's because undetermined is not a finding of liability. That is what the whole statute was meant to protect from. So there is no case law that suggests that the word undetermined should be redacted from a death certificate. The Commonwealth bears the burden of proof in this case. They have to prove beyond a reasonable doubt that a homicide occurred. And the Commonwealth's own medical examiner has opined that she was unable to make that determination in this case. That finding is relevant, it's exculpatory, and it should not be redacted from the death certificate.
So you say the medical examiner is not testifying?
It's not, I believe the medical examiner is not on their witness list.
Oh, I thought I saw Dr. Scorti-Bello. Oh,
Not on their witness list.
right.
Just number 81 on the Commonwealth's witness list.
All right. I'll take this under advisement. I'll take a quick look at Ellis again.
I would just note, I apologize. I know Attorney Brennan did represent at one point, they are not likely to call the medical examiner. So that was my impression.
Okay.
Perhaps I'm incorrect.
That's fine. Thank you. All right. One last, hopefully quick one. Commonwealth's motion to eliminate to introduce certified records from the Registry of Motor Vehicles. Is there an objection to that, Ms. Little?
No objection.
Okay. Probably one more quick. So that's paper 580, Jim?
Thank you.
Commonwealth's motion to eliminate with the intent to obtain query records of potential jurors. That's allowed as long as it doesn't disrupt the trial in any way.
May we be heard on that? Ellen?
Sure.
Your Honor, potential jurors are asked when they fill out the jury questionnaire whether they have a criminal record. They're also asked if they know anybody in law enforcement. They're asked if they've ever been a victim of a crime. And for every other answer on the questionnaire, the parties must accept the potential juror's answer, which that juror is giving under oath on the form itself. In fact, there are times when a court may deny an attorney from inquiring further about a clear answer on the jury questionnaire, precisely because the answer was clear and it was given under oath. It is solely through the issue of a past criminal record that the Commonwealth seeks to question whether potential jurors are telling the truth. If someone claims not to know law enforcement, the Commonwealth is content with that answer. Does not ask for permission to conduct any further research. If someone claims never to be a victim of a crime, again, the Commonwealth is content with that answer and is not curious about whether the potential juror is telling the truth. In other words, it is the potentially hidden, if the potentially hidden information benefits the Commonwealth in their viewpoint, they're fine with that. The only way to make this process fair to both sides, therefore, with regard to this motion, would be to release to the parties the jurors' questionnaires in advance of trial so that each side can do their own independent research and investigation to vet the potential jurors in the pool. I know that there is case law to support the invasion into a juror's privacy regarding a check on the existence or not of their criminal records and a vetting of potential jurors' truthfulness. But it is interesting that the very first case the Commonwealth cites, the Hampton case, stands for the proposition that criminal records of prospective jurors are not an indispensable or necessary means to the selection of an impartial jury as a matter of federal or Massachusetts constitutional law. That was a case in which the defense had sought a query check of potential jurors, and the judge denied that request. And the SJC said it was fine to deny the defense's request. That means, Your Honor, that you would be justified in exercising your discretion to deny the Commonwealth's request to be allowed to invade the privacy of potential jurors, because pursuant to Hampton, it's simply not an indispensable or necessary way to select an impartial jury. Having said that, Your Honor, if the court is inclined nonetheless to allow the motion, we ask for an order that every bit of information turned up by the Commonwealth in their investigation of jurors be turned over to the defense.
I think that's the common practice of this office. What do you say to that, Mr. Brennan?
Is it the common practice of this office? Your Honor, is the court's question common practice of giving everything, or is it common practice of running queries?
It actually seems to be both.
I believe I've been informed that it is the common practice, and that is the practice we would follow to give everything to the defense. I think the assumption that the Commonwealth would not want somebody with a criminal record on the jury might be misplaced. Somebody who has a criminal record shouldn't be precluded from jury service. In fact, it may be people who have a criminal record in re-entered society who the Commonwealth would embrace as jurors. But sometimes people forget or mistake that they have a criminal past. And I understand may have happened in this case, has happened in many of my cases. And the nature of any past criminal record is sometimes helpful to see if there's an association between that and the charges in this case. So we would embrace providing everything to the defense and ask the court to allow our motion.
All right. If you remember, I give a catch-all, too, to the jury that sometimes we're in a hurry to fill out these forms. Sometimes that when we get these questionnaires, we think, well, this situation may not apply to me. So I give them time before they come up. And I specifically say, perhaps your experience as a witness or a juror or a defendant in a criminal case, or if there's any prior record, things that you may have forgotten. If you didn't include it and you remember it, please tell us when you come to sidebar. And inevitably, every trial, there's somebody that says they forgot to say something, or they had a record that, got in trouble when they were 17 or something. So it happens.
Right, and that's an argument against the Commonwealth's motion, because you're giving the jurors a chance to correct what they put on the initial form. There's no need for the Commonwealth to do their own independent research to confirm or deny that.
All right, so you're asking me to flat out deny the motion, but if I allow it, you'll get the copies?
Correct.
Okay. All right, why don't we take the morning break at this time?
Why
and we'll
don't
come
we?
back,
Take a look at my bracket.
and we'll do that motion, the defense motion regarding Dr. Welcher.
All right, please.
You are muted.
right. Well, we're here on lunch break. You guys want to see my my bracket? Why not? Let's take a look at my bracket in the men's challenge here. Let's take a look. Boom. View bracket. Yeah. Auburn. Look at this. Pained me to pick Michigan, but shit. I got Yale beating Texas A&M. I got Akron beating Arizona. I got VCU beating BYU. I almost went with Montana. They can score. But Wisconsin's going to just nip them. I would take the points in that game if I was betting. St. Mary's, Alabama. Alabama scores the most amount of points per game at 91.5. So you always take a team that can light it up. You got to take them. So I have Iowa State beating Michigan State, Iowa State beating Auburn, and Duke beating Alabama up top here. But down here, I have Houston losing to Gonzaga. High Point upsetting Purdue and then Clemson. They can flat out score. Florida, I got Colorado State coming out, making it to the Sweet 16. Florida's going to beat them. Oh, I have them actually going to the Elite Eight. Right here. What's the other one? I have Drake beating Missouri. St. John's out all day. Rick Pitino, baby. Come on. Last run here, buddy. I got Rick Pitino winning it all against Duke. I love Rick Pitino. Huge Kentucky fan back in the day. Love it. Love it. So, St. John's. I want Rick Pitino to win. Yeah. I have Houston, though, losing to Gonzaga. I was going to have Gonzaga. I have them going. I like Illinois as a sleeper team. So I got a 6, a 3, a 2, a 1, and a 6 advancing to the Final Four. I think the easiest number 1 that has the clear path is Florida. The easiest. I think Houston has the toughest road to the Final Four. Alabama, Alabama sucks at free throws, man. Foul them. So, Xavier's in it. So, I have them losing the tough one. Anyways, those of you guys that are watching, we are on the lunch break, or not the lunch break, but the morning break. Woo! I'm in Yahoo's 25,000 bracket buster. This dude does $20 per bracket. There's 850 people in it. It's going to be a nice payday. The top 3. And then I did a fun one with Cleveland State people because they're just fucking wild. 25,000 people are in that one. Yeah. Duke has an easy road. That's why you got to advance Duke. Duke has the easiest road, in my opinion. The toughest game will come to go to the Final Four. I mean, I think that Liberty can beat Oregon. I think that as long as my Iowa State team here does not get bumped by Lipscomb, they're going to be fine. This is the only hiccup right here. If they go into that game with their heads up their asses, Cyclones. I picked the Cyclones because of Little John. You guys want to know about that song? So I pick all my teams that I don't know how I feel about. I pick them by like songs. So here's why I picked the Cyclones. Taking us back, T-Pain. But yeah. So if you guys didn't fill out your brackets, come on, get on your brackets. It's March Madness, man. NC Wilmington, they have a chance. They got a chance over there. Who else? I'm telling you, High Point, mark it down. Go to the casino, bet, take the points, High Point all day. They're going to win motherfucking outright. Take your 16.5 and bet the house. Bet the house. High Point plus 16.5 all day. That's the easiest grand you'll ever make. Bet it all. Parlay them. Parlay High Points. Take the points in 3 games, and I would take Montana, High Point, and Yale. 3-team parlay. Take the points. Fuck it. Go into a teaser. Get more points. Those people are going to win outright. So, I knew you were going to play that song. There you go. Yeah. Florida is a monster. Come on, tell me you guys have got into your brackets. It's about to tip. Did it tip yet? Let's see. March Madness scores. And that hasn't tipped yet. Dude, UNC beat the shit out of San Diego State. Just letting y'all know. UNC put up 95. They're hot. They're hot. UNC is hot. Hopefully they're tired. 12:15 is the tip. So you guys got 1 hour and 15 minutes. I should fill out some more brackets. Heck, well, that Yahoo bracket with 3 winners right now is what, $5K for each winner, isn't it? I don't know which one that is. I was just looking at the spreads on these games. I'm like, damn. Get your asses down to that casino. There's a lot. So it tips with Louisville's tipping it all off at 12:15. Then 12:40 is High Point Purdue. I'm telling you, High Point is going to win outright. They are good. They are good. They're going to create a matchup problem too. They got a 6'10", dude. I'm telling you. High Point is shooting 43% from the 3-point land. Okay. Montana, they can score, but I just don't know if they're deep enough. If they get into foul trouble. Houston, 2 o'clock. They're just gonna blow them. Auburn. I think upset alert for the first 1 seed to go down is right here. Where's my bracket? Where's the I mean, that's a tough matchup right there. That's a tough matchup. If Baylor beats Mississippi State, Baylor has a way better chance of beating Duke. It's just a matchup game, but Mississippi State matches up way better with Baylor. But they don't. Like Duke, that's not a good matchup for them. One over here. Auburn's the first 1 seed. I say that, I think they're going to be the first ones out. Auburn for the 1 seeds. Oh, yeah. Is that what it is? It should be. I think it goes, he pays out, well, usually the winner of that usually gets 10 grand of his $20 one. That'll probably jump from like 800 to like 1,000 people by the time it tips. I thought they must have moved it back a little bit because I swear they used to start these, I thought, like right at like 11:30, 11:40. So we got some time. I'm influencing you guys to go gamble. Bet the house, High Point. I'll take High Point. Who even knows where High Point's located? How about that? There's some fun fact for you. Where's High Point even located? Oh, I was listening to, on my way to take Jack to school this morning, they were doing multiple choice spring breaker questions. And did you guys know, fun fact, I'll see if you guys can answer this, what Florida city was the first to dub like spring break? And the answers were either Daytona, Fort Myers, Fort Lauderdale, or Miami. What do you guys think? It was 1932, 1936 it was dubbed. And it's interesting because I'm going to tell you the answer. Yes, winner right there. Fort Lauderdale. And it happened because I learned some interesting facts. When I had my trivia business, we had accounts in Fort Lauderdale. And I always stayed at this hotel, which was next to this like enormous Olympic size outdoor pool. And it was like weird. It was like half indoor, outdoor. It was really cool. Anyways, this was this Olympic pool that back in New York during spring break or like, the spring time of college, this school that was training took the team from New York to go train and work out in Fort Lauderdale at this Olympic sized pool. So Fort Lauderdale became spring break. And fun fact, Fort Lauderdale's nickname is Liquordale. Did you guys know that 4,000 bars and restaurants are in this little corporate limit? 4,000 bars and restaurants. And so they got dubbed Liquordale. So instead of Fort Lauderdale, it's Fort Liquordale. Yeah, there you go. 1938. Whoa, won a swim coach at Colgate. There you go. See? Who knows? There you go. Hey, listen. Isn't that sweet? Look at that. What was one of the other ones? Oh, in the 1940s, what happened that grew almost double the amount of spring breakers in the 1940s? There was a spike in spring breakers, and I was dying. And they were like, option A is the bikini was introduced. B was the German submarines. The Germans, they were doing these submarines, and they were over basically on the Gulf Shore over there. And they then invaded spring break. So that was option B. Option C was, what was it? Buy one, get one. Everything was buy one, get one in the 40s. And then something else was option D, was totally stupid. Totally tossed it out. And the answer is the submarines. The Germans, they all then went to spring break. And so it saw a huge peak in the 1940s. These people answered the bikini. I about died. They were throwing answers like option A, bikini. I was like, what? When was the bikini even invented? Way before that. Then the next thing is what was the first spring break destination that was a huge hit in the 80s and 90s, and it was outside of the U.S. And the options were, I don't know if did they give them options? Oh no, it was inside the U.S. but outside of Florida. Option A was New Orleans. Option B was San Pedro. C was Venice, and D was Myrtle Beach. And I was like, oh my God, this is so easy. All day. San Pedro, Texas, all day. You guys remember like Spring Break MTV? San Pedro? South Padre Islands, not San Pedro, South Padre. I was like, oh my God, I know that from back the MTV days. South Padre. These people were answering Myrtle Beach. I was like, what the fuck is going on here? It's not warm enough there. Myrtle Beach for spring break. Yada. Answer was Texas, South Padre Islands. I want to go there. I've never been there. I want to go there. I wanted to go there back when it was on MTV. So, all right, let's head back to Bev, just talking about some more bullshit. Bev. I don't even know if I'm going to cover the second half of this. So these are the takeaways, though, guys. She said, I'm denying the motion. Like, this trial is starting April 1st. Okay, this trial is starting April 1st. So that even gives me more, like, that whole motion that was even before that with the Rule 17 to get the phones. That has to be denied now. You know what I mean? So, but Bev says, we're going. We're not looking back. Trial starts April 1st because it will take us 10 weeks. 10 weeks to do this whole jury thing. Alan Jackson's like, yeah, that's fine. We just care about, we're making a record here. All right, we sent an email to the Dedham Community House, which houses the farmers market, which is like right in like the grassy area. And them wanting to close down Court Street in Ames. The reason that these people bitched, okay, is because where is anybody supposed to park? So the farmers market in Dedham Square is literally here. I'm going to show you guys a map. This is why this is all that buffer zone. There's no way. I'm so happy that they called in. Let's take a look. Here we go. This is your map. This is our map here. So, see, they want to close down Ames and Court Street there. This is, let me blow this up just a tad here. All right. So, see this area right here? This all right here is where people were lined up. There's a courthouse, right? Yeah. This is where, right here, is where the defense team was hanging out. So this is this area where the SUVs were. But to close down this Church Street, which, where's that? Court Street. They want part of this closed. I think it's over here. But they always take like this that grassy area and all the pavement right there for that's like every Wednesday. Every other Wednesday. But ridiculous. I'll tell you what, though, it was a pain to get Ubers to come pick you up down there. Yeah. Yep. What's up, Johnny Lunch Bucket? Seeing all that Idaho CI shit? I bet you like that. Nice visual, Anna. Thank you. Just bringing the visuals over here. So big takeaways. Yes, trial April. Hank wants to have a big old voir dire, and they want to bring in the ARCA people next week to have this voir dire. And it's basically to see what parameters, what's going to be, what they. Hank's over here saying, I don't have anything from them. Hank wants all this shit. And so I'm unclear because the defense has to disclose in the reciprocal discovery if it's going to be relying on reports or whatever. That's part of reciprocal discovery. So what Hank should be talking about is that I don't have anything. Like, this is what I have. This is what I don't have. Well, he should just be talking about this is what I have based off of this. I mean, if it has an opinion on it, if it has, I'm sorry, you don't use voir dire you're not cross-examining them. I don't understand. I feel like he's using it as a way to, if these guys say something different in voir dire and then they say something different during the testimony. That's kind of what I gather from it. Now, Bev seems to think, and this is crazy, she says that it's going to take us a while to get this jury impaneled. She thinks that the jury isn't going to be impaneled by April 25th. Did you hear her say that? That just blew my mind. What is she talking about? How? You guys, I learned, unless they're just going to be dismissing people like based off of, have you heard about this case? Okay, you're gone. There's no, I don't, she's, it's not going to take from April 1st to April 25th to impanel a jury. I mean, are we working 1 hour days? Sidebar, Lana. Hey, how was your birthday? It was great. This trial needs to be sponsored by Truly's and White Claw. Like, just Truly's for the win.
Before we begin, realizing how much everybody has to do before this trial, I won't have the voir dire of the ARCA witnesses next week. We'll have it before they testify. We'll do it the day before they testify.
Right.
And we'll give you until then to comply with all Rule 14 discovery and see where we stand. So we don't need to bring them here next week unless you made arrangements.
No, I didn't make arrangements. I just want to make sure that we're very well defined on what issue is before the court that would justify a voir dire. I just want to make sure I don't think that's been clearly articulated. I just need to know what the parameters are.
Okay.
We need to know. I think Mr. Alessi is going to handle the argument in substance, but I need to know what are we dealing with for voir dire.
Okay. All right, so what I need you to do beforehand is make sure that all Rule 14 discovery is complied with, and if it is, then we'll see. Okay?
Okay, so it's basically
Yes.
defined on Rule 14.
Yes.
Got it. Thank you.
Does that work for the Commonwealth?
My concern is if we have questioning of the witnesses the day before their testimony, and part of that includes the production of records, and they don't have the records with them, they're going to be unable to produce them because they would have to return home. And so having.
So we'll need that, Mr. Alessi, okay? Well in advance.
Yeah, understood.
That would be part of the Rule 14 discovery. If they comply with Rule 14 discovery in advance, you'll have all of that.
That was exactly my understanding, what Your Honor was suggesting, and we will comply with that.
So see where we stand. If we need to address it, we'll address it before then.
My discovery motion extends beyond Rule 14, and the reason why is it includes the communications between the parties. Which
Oh, now he wants to put this in.
Rule 14. We have a court-ordered discovery motion that we filed that includes the request for this information to show bias, and I don't want that to be overlooked.
All right, so talk to Mr. Alessi in advance. All right, and I'd like you to be able to tell me before we start the trial where you stand with that.
Bev, what aren't you listening to? He wants things that are outside of it.
Need, Mr. Brennan.
I'll inform the court.
Okay.
Now, please speak with Mr. Brennan at Your Honor's direction.
All right, thank you very much. All right, so now we'll go on to your motion, Mr. Alessi.
What motion?
May it please the court. In my presentation today, with regard to Dr. Welcher,
No, I was just wondering if you're going to tell me what you're going to tell me and then tell me what you've told me. Do you plan on doing that or are you just outlining it?
I do not, Your Honor.
Thank you. Go ahead.
In my presentation today, Your Honor,
Dead.
I'm going to,
Done.
just so Your Honor has the documents in front of you that I'm going to be referencing. I'm going to be referencing the 140 slide presentation.
Okay.
What the Commonwealth has dubbed a report, which is approximately 12 pages of a letter dated January 30, 2025 from Dr. Welcher to Mr. Brennan. And I am also going to be referencing a case law that the parties have cited. What Dr. Welcher has submitted is notable both for what is submitted and what is not provided. Dr. Welcher has gone extraordinarily well beyond not only his area of expertise, but he has, and that's in terms of what he has provided, but as remarkable is he has not provided any documentation of how his methodology is tethered to any study, any common acceptance, or any of the Daubert factors. And this, again, is a pattern of the Commonwealth where they provide, as they did with Dr. Wolf, as they have done with Dr. Crosby, they provide long CVs, long qualification lists, and then are completely silent on the tethering of the methodology to a common acceptance or the Daubert factors. So that is the jurisprudential motivation for me to hit the case law with regard to why that deficiency is fatal to their burden of proof under the Massachusetts law. So I'll start with case of Canavan, the SJC's decision of 2000. And I am going to provide 4 parts of Canavan. Number one, it's in head note 11. And this case was about, as the court may know, the Commonwealth, not the Commonwealth, a party proposing an expert that was commenting on, which was fashionable at the time, multiple chemical sensitivity. And the expert witness trying to state that an individual suffered from multiple chemical sensitivity. Here's what the SJC stated in response to the expert that was proffering that testimony, and it's extraordinarily close to what is happening with Dr. Welcher, what happened with Dr. Wolf, and Dr. Crosby. The SJC said there was no evidence in the record to show that Dr. LaCava, that was the proffered expert, used a reliable methodology to transform his general finding of chemical exposure to his more specific diagnosis of MCS, multiple chemical sensitivity. Immediately after that, the High Court said, and I quote, Dr. LaCava referred to the, quote, literature as confirming the existence of MCS and asserted that based on the examination and tests he conducted, the employee had symptoms highly suggestive of environmental sensitivity. However, Dr. LaCava did not identify any specific studies that showed the existence of MCS based on specific symptoms and did not identify tests that can be performed to prove that the patient suffers from MCS. Skipping one sentence. Thus, the only evidence on this record tending to show that the employee suffered from MCS was Dr. LaCava's assertion. The purpose of the Lanigan test is to prevent an expert from offering testimony to a fact finder that is not based on a reasonable or reliable methodology. We cannot conclude that the expert's mere assertion that a methodology is reliable is sufficient to pass the Lanigan test absent any other evidence showing its reliability. And I have used the Latin phrase ipsi dixit, translated into because he says so, or he said. And it's not my pejorative, that's the ipsi dixit comes right and is used in case of cannabis. And that's what the SJC calls it when you don't tether a methodology to a study or common acceptance. It's just that expert witness saying it. The reason I perseverate on this is because that's exactly what Dr. Welcher is doing in a 140-slide presentation. It's exactly what he did in his 12-page letter to Mr. Brennan. Nowhere in either of those voluminous documents does he mention one word about two things he did. He did an analysis. He has a purported methodology, just like Dr. LaCava in case of Canavan. He doesn't mention one study to support his methodology. Unless there be any concerns, the law is clear that the Lanigan analysis is applicable to medicine, science, and technology. And clearly, Dr. Welcher is in the technology area. In the Dalbert Lanigan analysis, it's referred to as the hard science. So he also, Dr. Welcher, conducted an experiment. And I'm going to treat that separately from the lack of a methodology. So I want to stay just with the methodology that is purported to be used by Dr. Welcher. So keeping on with case of Canavan, Dr. Welcher also is proffering to provide opinions on the medical causation of the injuries to the right arm of the deceased. It's clearly what he is doing. Here is what the SJC said about causation. It's head note 14, and they labeled the heading of it causation. The SJC said, quote, there is no suggestion that the judge conducted a Lanigan analysis to determine whether Dr. LaCava used a reliable methodology to conclude that the chemical exposures to which the employee was subjected caused, and caused is italics in the opinion, her to suffer from MCS. This was an error. They went on, quote, because understanding medical causation is beyond the knowledge of the ordinary layman, proof of it must rest upon expert medical testimony. Because and I'm skipping several sentences, because the judge below did not conduct a Lanigan analysis to determine whether Dr. LaCava relied on a reliable methodology to determine that chemical exposures caused the employee's MCS, it was an error to admit the opinion. In the concurring opinion of Justice Greene, he added an important point. I quote, further and perhaps more importantly, the application of the standard will make little difference in how an appellate court decides a hard science. The issue was, what was the standard of review? Is it going to be abuse of discretion? And the concurring justice said, in hard science, it really doesn't make a difference. But here is apt for what we're here for today. The goal of Lanigan, as was the goal of the preceding tests, is to keep unreliable or so-called junk science from fact finders, thereby reducing the prospect of the return of verdicts or the rendition of decisions with dubious validity. So I rehearse apt provisions of the case of Catavan because the SJC sets forth what the burden is of the proponent. And I know Your Honor has heard me make this argument before, but I am now providing the SJC decision for direct support what I've said with regard to the experts, Dr. Wolf, Dr. Crosby, and now Dr. Welcher. Next case I provide is Commonwealth v. Meeks. And that is another SJC decision. And if I'm not mistaken, I think all of the cases that I'm providing in my oral argument are cases cited to by the Commonwealth as part of this motion. I'm not 100% sure with regard to Meeks, but I think it's a decision that they cite as well. And oddly, all these decisions favor the defense. So here is, I'm only going to need to read one part of Meeks, even though it's a very long decision of 2006. It states at 2006 Westlaw 2819423, and this is on page 53 of the Westlaw copy. Quote, at trial, this court will require the Commonwealth's firearm identification witness to provide on direct examination, et cetera, et cetera. Last sentence. Such discovery is essential to an effective cross-examination and therefore to a fair trial. And I've made this argument many times before about the prejudice to Ms. Reed from the pattern of the Commonwealth to provide experts, long reports, long CVs, completely silent on tethering the methodology to a study, etc. And the SJC points out that that information is quote, essential to an effective cross-examination and therefore to a fair trial. And with regard to the last case that's really more apt to the experiment that Dr. Welcher apparently performed, not apparently did perform, that is the subject of his slide presentation. And this is, there's various experiments, but the most prominent of which is painting someone's arm blue, painting a hand yellow, and then trying to use the results of that experiment to support some wayward theory as to how the SUV made contact with the decedent. There's no doubt that's an experiment. So it's important when I get to that experiment, what the legal standard is before such an experiment can be admitted in evidence, and what's the test under the Commonwealth v. Davis and Lanigan as to how an experiment could possibly come into court. So you've heard of the case, and I know Your Honor knows of Rintala. We basically cited it for the proposition of qualifications, but substantively, we haven't talked about it. And I know Your Honor is well familiar with it, so I'm just going to summarize what's apt for our motion. Okay. What the High Court said there is that the precise question is whether Giulianelli, this was the paint expert proffered by the Commonwealth, possessed sufficient education, training, experience, and familiarity to determine forensically when and how the paint was applied to the basement floor in the victim's body based on the information he was provided. And a large part of Rintala was, listen, this person was a paint engineer at his company, and he had a lot of experience in that. But what he really didn't show and didn't have was experience forensically addressing the question. And that was certainly a big part of Rintala. So the court, to that point, said there is a significant distinction, however, between what Giulianelli had done in the paint industry for over 20 years and what the Commonwealth asked him to do in this case. So the court went on and discussed the difference, and it said he also, this is Giulianelli, he also did not do any research on the topic or search for any academic or industry materials on this topic. So the court, with that predicate as to what was lacking, which is completely the same as what's lacking with Dr. Welcher and his experiment, the court said this, and this is on Westlaw copy 14, head notes 19 through 22. I quote, expert testimony also may be based on or informed by the results of experimentation. Skippy. The conditions in the experiments must nonetheless be substantially similar to those at the crime scene for the experiments to be of any value, and where new hard science is involved, an appellate court will always take a hard look at the trial judge's decision to admit or exclude the evidence. So here's what happened that's very apt to Dr. Welcher. Our analysis of Giulianelli's approach begins with the important principle that judges should closely scrutinize expert testimony where the testimony is prepared solely for the purpose of litigation, as opposed to testimony flowing naturally from an expert's line of scientific research or technical work. There is no evidence whatsoever in the Commonwealth's papers that Dr. Welcher had ever performed this experiment as part of his line of scientific research or technical work. From all indications, it appears that he performed this experiment specifically and exclusively for purposes of this litigation. And that's where the SJC started. So they immediately said, if it's just experiment done for this litigation, we right off the jump have a big issue with it. The SJC then goes on with this very, very questionable area of experiments and said, rather than flowing naturally from his work, therefore, his experiments greatly differed from the work he ordinarily performed and the observations he had experience making in the key. And his opinions were developed solely to assist the Commonwealth's prosecution of the defendant, which from all indications appears exactly the purpose of Dr. Welcher. And here now to the tethering of the methodology to a study which Dr. Welcher does not do at all. The court said, footnote 31, because Giulianelli conceived of and designed the experiments without any stated basis in existing science or literature, and because neither the Commonwealth nor the trial judge applied the Daubert-Lanigan factors, it would make little sense to attempt to apply them here. The SJC said, we're not even going to go do this analysis because the proposed expert didn't cite to it. So we're not going to guess at what happened. And it then said, relatedly, and I'm quoting, the Commonwealth has not pointed to any basis in existing scientific literature or research for Giulianelli's methodology or experience. Instead, it appears that Giulianelli designed these experiments on his own without any guidance. Reading down below, quote, Giulianelli's experiments also do not appear to have been performed consistently with basic scientific principles. We have no evidence in anything the Commonwealth submitted that the experiment of Dr. Welcher was performed in accordance with any scientific principles, because his report and the slide presentation is completely bereft of any citation to basic scientific principles. Next, the court said Giulianelli did not repeat or validate any of his 6 experiments is also significant. There is 0 in the current record that Dr. Welcher repeated or validated his experiment. Nothing. That is the legal standard for experiments in the Commonwealth of Massachusetts. It's not the defense creating the standard. It's not the defense suggesting what the standard should be. What I just read is a 2021 opinion of the SJC. With those important legal precepts stated, I now turn to the letter, what the Commonwealth provides as, or calls a report, which is the January 30, 2025 document from Dr. Welcher. And I start on page 9 of that report. And if Dr. Welcher had adhered to his own standards about what a biomechanical engineer is to do, my presentation would be much shorter. So let's see what he said the role of a biomechanical engineer is, and then what he did. Because this goes to the point of him exceeding the scope of his qualifications wildly. So on page 9, he said in the first full paragraph under numeral 11, he says, in the middle of the paragraph, my biomechanical engineering analysis is determining the effects of physical forces on the human anatomy. I have not made any type of diagnosis. He then goes down below, in 2/3 of the way down, he says, injury causation analysis is a multidisciplinary endeavor that employs objective medical and biomechanical data and analysis to determine whether a MVC caused a pathological condition or symptom diagnosed clinically. He continues, the entire body region will be covered under 3 of the 4 main branches of impact biomechanics, which are injury mechanisms, mechanical response, tolerance, and the biofidelity of surrogates. Thus, injury criteria are needed by biomechanical engineers to describe the relationship between one or more physical parameters and the injury they cause. These criteria usually take the form of a simple mathematical expression or a force or acceleration level. I couldn't agree with him more that that is what biomechanical engineers do. And he then goes on the next page, first full paragraph, I understand my current assignment in this matter is to analyze the available data in this case, including but not limited to the data in and damage to the Reed 2001 Lexus LX 570, and to determine the events that applied forces to Mr. O'Keefe that resulted in the damage to his body, structural failures, fractures, injuries. I agree completely again. That's what a biomechanical engineer is supposed to do. And what is it that he's talking about with force acceleration? At the risk of getting a little too nerdy, but it's really important. What biomechanical engineers do is they apply Newton's second law of physics, which is force net equals mass times acceleration. That's the mathematical formula, because biomechanical engineers want to know what's the force being applied. And when you do that, then you can then say, okay, is this force capable of causing this result? And if that's what Dr. Welcher had done, again, my presentation would be very short. But that's the setup that he says are his guardrails, his boundaries. Now let's see what he actually did in this case, is where we have great objections. It's his conclusions and opinions, which take up about 1.75 pages only on page 10. Let's see what he did and how he honored or didn't honor his own standard. And I'm going to, hopefully to assist the court, identify what I believe should absolutely be disallowed from him opining on. Conclusion opinion number 1. I'm not going to talk about things that we aren't contesting. I want to go to the things that are clearly wayward and improper. 1C. He cites to Julie Nagel and occupants of Richard D'Antonio Ford F-150, Ryan Nagel and Heather Maxim, arrival in time outside 34 Fairview, not seeing anybody exit Lexus or damage to the Lexus. What he is doing is he is not only using, but he's trying to credit contested testimony.
So let me find out, do you intend to introduce that testimony, Mr. Brennan, through this witness?
I intend to introduce that testimony prior to Dr. Welcher testifying. If it's not in the record, he would not be able to testify to it, but if it is in the record, he can refer to it as part of the testimony.
All right.
That's a very apt question, and Mr. Brennan's answer underscores the issue. So what I understand completely the foundational evidence issue. I understand all of that, but the transcending issue is an expert witness can't use contested testimony because experts are not allowed to credit and talk about the credibility of witnesses. It's clear case law in every jurisdiction, including Massachusetts. And he does that throughout his report. And we've provided in our supplement correction the clear case law. I'm not going to go through it because I know Your Honor knows this. It's almost Hornbook law. So based upon Mr. Brennan's answer, it only underscores and establishes our concern. So 1C should be excluded. Now to 2. 2A Romanettes 3 and 4. Romanet 3, 2A3. No evidence light was broken at 1 Meadows Ave. When does a biomechanical engineer get to testify about a contested issue and say no evidence? That's not for a biomechanical engineer. And when he set up his own boundaries, he didn't talk that he was going to be looking at contested evidence. Romanet 4, 2A4. No fragments of taillight on or in snow behind O'Keefe Chevrolet. That's an evidence, collection of evidence, preservation of evidence, etc. It's not for a biomechanical engineer. Then he goes on to 2C. Testimony of Jen McCabe. That's his heading. Karen Reed stated to her, etc., etc.
Hearsay.
In other words, given Jennifer McCabe's testimony, and then he talks about what he believes Ms. Reed knew. That is not only trying to credit testimony, we've got now a biomechanical engineer that is going to be stating the Commonwealth's case for it. What is the biomechanical force calculation for talking about Julie Nagel, Ryan Nagel, Jen McCabe, to frankly anybody's testimony. It's unprecedented. Now, continuing on page 11 at the top, and this is C Romanet 1-1, 42622 Julie McCabe, 42622 state grand jury page, etc. Grand jury minutes. It's testimony. It's testimony of lay witnesses.
Yeah, right.
Inherently, he is crediting that testimony as truthful. That's not what any expert can do, let alone a biomechanical engineer. Number 3, the location and orientation of the laceration on John O'Keefe's right forearm and arm are consistent with the geometry and orientation of the right tail light of the Reed 2001 Lexus LX 570. So let's cut through the euphemism of orientation. What he is referring to is pattern recognition.
Let's get the shot.
He is saying that the pattern of the lacerations on Mr. O'Keefe's right forearm are supporting his opinion. Where is his qualifications to determine pattern recognition of a wound on a decedent? They don't exist. 4, and that should be stricken and not allowed. 4, perhaps the most egregious of all, and I respectfully submit what I pointed out are incredibly egregious. 4, the totality of the evidence is consistent with the right rear corner of the Reed 2021 Lexus impacting, etc., of his head on the frozen ground. So there are several maladies with that statement. First, where is his qualifications to testify as to frozen ground? He's not a pedologist, he's not a hydrogeologist, he's not a geologist. He has no basis to testify in that regard. But more importantly is his phrase, the totality of the evidence. And if Your Honor now looks at what he considers to be the totality of the evidence, it is extraordinary. He is, and I will state each one, he is becoming a medical examiner. He's becoming a lead investigator. He's becoming a cell phone data forensics expert. He is also, once again, talking about testimony of individual witnesses. So he says the totality of the evidence is consistent with the right rear corner of the Reed Lexus impacting John O'Keefe and Mr. O'Keefe, etc., and of his head on the frozen ground. So what he's doing is he's now talking about cause of death and manner of death.
Do you intend to introduce that evidence, Mr. Brennan?
Wouldn't be introducing evidence of frozen ground, Dr. Welch. Is there other parts of the
cause of death?
He would not be offering a cause of death. I think the spirit of the report is putting all the information together to see his observations, but I recognize that he's limited to his field. The hard ground and the cause of death are not within his bailiwick.
All right, thank you.
Again, appreciate that apt question, and I'm going to go into why there's still an issue. So I think it's best just to go.
He can say whatever he wants right now. Once this trial starts, Brennan's going to do whatever the fuck he wants.
Of the evidence. Cell phone data. Where's his qualifications to discuss cell phone data? That's a data forensics. We had obviously many moments I'm sure your Honor may wish to not remember, but with regard to Mr. Green, etc., we went through a lot of issues about the expertise needed, the methodologies, the various tools. Where is his qualifications to talk about cell phone data? There are none. It's improper. So A in its entirety should be stricken. C, forearm lacerations, 3 above. So that goes back to the euphemism orientation where he wants to talk about pattern recognition. And it's interesting that the Commonwealth vigorously contested Dr. Russell, and we all know her credentials on pattern recognition, but yet they're proffering a biomechanical engineer to talk about pattern recognition. D, air temperature and frozen ground. I'm understanding, if I understand correctly, that the Commonwealth is now stipulating to excluding that. And it's really the frozen ground aspect of it, of D. Then E. I'm sorry, Mr. Brennan.
I don't mean to interrupt. The frozen ground, we're not going to bring in. The air temperature is important because it talks about the density of the strength of the tail light. And that's part of the conclusion. So there'll be evidence before he testifies about the weather we expect. And you can rely on that to talk about how that might affect the tail light. But frozen ground, we agree, that would not come in from Dr. Welch.
We have no objection to the air temperature testimony of Dr. Welcher.
Okay.
E, hat line and fracture location consistent with fall and posterior head strike. Extraordinary. Even the medical examiner in this case wouldn't venture onto that. But that is clearly an example of what I'm talking about in terms of Dr. Welcher going well beyond his field. He's talking about hat line and fracture location. That's a wound to the back of the head. And to make matters worse, he makes clear fall versus assault. He's making a distinction between a fall and an assault occurring. We've contested Dr. Wolf on that issue. Now with regard to F. This is the wayward, undocumented experiment that Dr. Welcher conducted. F, Romanet 2 should be excluded. It says drop test conducted by me with a hybrid 3 falling backwards, measured heads, G's of approximately, et cetera, et cetera. That experiment I've covered in what the case law requires for him to show. There is zero support for this experiment. I went through in Rentola, I won't repeat it, of all that needs to be established before an expert can talk about an experiment. Dr. Welcher supports his experience with zero. This very experiment that he did, this drop test, has zero documentation of where the methodology for that is supported by science. Recall in Rentola, the paint person conducted an experiment and the SJC said, yeah, you conducted it. Yeah, you know, this is your area, but you've got to show all of these things, including where is this supported by the scientific method? What studies? Did you repeat this experiment to make sure that there wasn't an error rate of concern? Every single deficiency in Rentola is extant with Dr. Welcher. His experiment must be excluded if Rentola is to have any meaning in Massachusetts jurisprudence. G, Julie, Nagel, and Ford occupants. Again, what does he say? Pulled in behind Lexus and never saw anybody enter or exit Lexus or walk into 34 Fairview. He's crediting, again, testimony and contested issues with regard to some important issues in the case. Unprecedented, the biomechanical engineer gets to come anywhere near that. And we provided, again, the clear case law where in Massachusetts that's not allowed. And as egregiously, H, people inside of 34 Fairview on evening of 128, early morning of 129. H, Romanet I. John O'Keefe never entered 34 Fairview. Is there any more of a contested issue than that? But yet he's proposing to testify and state that? What biomechanical engineering principle is being applied there? The answer is none. Except for Karen Reed, everyone at 30 and outside 34 that indicated John O'Keefe did not enter 34 Fairview. Even more egregious than H. Romanet I. So with regard to Dr. Welcher, I have, again, genuinely tried to assist the court with regard to blue penciling his report to make clear, based upon the case law, what is within his bounds and what is not within his bounds based upon his own stated parameters. And with regard to the case law about commenting, not being able to comment on a witness, crediting their testimony, Commonwealth v. Quinn, which we cite, says such testimony impermissibly intrudes on the jury's province to assess the credibility of the witnesses. So not only is Dr. Welcher beyond his qualifications, but he's intruding on the province of the jury, and the Massachusetts courts state such testimony, the kind where an expert witness assesses the credibility of another witness, could substantially influence the jury's decision about whom to believe. And lastly, and importantly, should the Commonwealth try to save this wayward part of the report by saying, well, you know, is he really directly or explicitly doing it? The Commonwealth v. Lopez case, and I quote, vouching for the credibility of a witness, here's the key part, whether explicitly or implicitly is impermissible. So I believe it's explicit for the reasons I've given, but even if the court were to conclude that some of his references to witnesses is not explicit what he's doing, it certainly at a minimum is implicit. So with regard to the experiment, the case law is clear as I have recited. With regard to this experiment, prepared solely for the purpose of litigation, not repeated, not retested, no documentation in the scientific engineering literature for the methodology or the experiment, dooms Dr. Welcher's experiment. And the bases in the jurisprudence of Massachusetts couldn't be clearer. Experiments come to courts with an extremely jaded eye, as Rintolo talks about. Both eyes get even more jaded when it's created purposely for the litigation. And what is clear from the case law is the prejudice to the defendant in these cases by allowing experts such as Dr. Welcher to stray into all of these areas. In conclusion, Dr. Welcher is not qualified to do anything more than what the ARCA witnesses did, which is talk about and calculate forces and then determine whether or not those forces are sufficient to, and based on physics, are sufficient. So, Your Honor, we would request that because all of these deficiencies so infect all of his report, meaning the experiment is the entire basis for his opinions. You pull out the experiment, he has no basis for an opinion. You pull out a lot of his items, there is no basis for his testimony, and it frankly shouldn't be the job of the defendant or the court to fly spec his report in his slide presentation. And that is the final data point I want to hit, which is his slide presentation. We have a 140-page slide presentation that is unintelligible on its own. You can't understand it, and the report merely references it. It doesn't explain it.
Let me stop. Mr. Brennan, do you intend to use this PowerPoint presentation?
Parts of it. It certainly needs redactions. Any reference to witness testimony needs to be redacted. Opinions on credibility needs to be redacted. But there are different demonstrations that we do expect. The demonstration at Meadows Road, which clearly depicts that the cars didn't contact the taillight, we want to produce. The drop test, similar to Archer's test, we intend to offer that. But as far as the extraneous commentary, no, that's not intended to be, it's not proper, and we wouldn't even try to introduce it.
Do you intend to use all 140 or however many?
No, that is, we were comprehensive in the production to the defense so they could see the data points, how it was produced. And so we've included, you see many of the slides is the cameras showing the different data downloads. There's only a fraction of that we would show. What we would show is the drop test, the demonstration of the Lexus hitting Mr. Welcher's arm, and also we would want to show the Waze locations based on the data that will be introduced through other witnesses and after it's been attested to and its reliability.
Okay.
If I may be heard on this?
Sure.
Thank you. I still don't know the answer to your question. The defense is entitled to know.
Right, so this will have to be provided to you prior to it's done.
Thank you. And do we have a date so we can adequately prepare for trial, Your Honor, in cross-examination?
When will you have the redacted slides?
I could have them by Monday.
Okay.
And Your Honor, if we have an issue, still, can we submit something to the court? Don't need another court hearing, but if Your Honor would like it, we're happy to do it just to get the basics.
Sure, so you'll get what you're entitled to, and which is just a narrowing down of what you already have. And then if you need to respond, you can respond and we'll take it from there.
Thank you.
Okay.
So in conclusion, Your Honor, the proffered information from Dr. Welcher is, in my experience, unprecedented. It is all-encompassing. It veers extraordinarily beyond his own stated boundaries. And even if he didn't state his boundaries, it's clear he's trying to perform roles, even with regard to what the Commonwealth has just said they're stipulating not to produce, still getting in extraordinarily to other disciplines for which there's no documentation. My last point is the point made by the Supreme Judicial Court. These experiments, especially of the insufficiency of Dr. Welcher, cannot be admitted into courts and go before juries for the reasons of the improper influence on the jury. And secondly, the methodology has to be tethered to a study or something in the literature to give the court, as the gatekeeper, a basis to say, this is science. This was done pursuant to the scientific method. And Dr. Crosby, Dr. Wolf, and now Dr. Welcher are completely absent with regard to that tethering. And as the SJC says, that deprives the defendant of cross-examination and a fair trial. And I don't know why the Commonwealth, I've been saying this for months, literally, as to why the Commonwealth doesn't produce it, either in reports or in their responses to our motion. I am left with one conclusion, Your Honor, and that is they don't want to provide it, and they want to, as the Commonwealth's favorite phrase appears to be, do trial by ambush. But that can't work with a defendant in a criminal proceeding. The Commonwealth can't ambush, and that's not my standard. That's the standard of the SJC. So we respectfully request that Dr. Welcher's report and his testimony be disallowed in its entirety. We will, of course, await the narrowing as Your Honor has ordered, and we would urge at a minimum that the defense know clearly what this witness is going to be allowed to testify to, and we would like to avoid an evidentiary hearing because I think it's pretty clear what the parameters are, but I have to reserve, Your Honor, our request in the alternative for an evidentiary hearing if what we get from the Commonwealth continues to be the vagueness that we've been getting all along. Thank you, Your Honor.
Okay. Mr. Brennan?
March Madness has officially kicked off.
Or Attorney Alessi sees this as some type of trial by ambush. I'm not going to digress the way he has, but a case study in that is the ARCA, and that's why I'm concerned about waiting until the day before trial to get simple Rule 14 discovery. ARCA and Mr. Welcher have some similarities because they're biomechanical engineers. Now, in our production, we gave over 8 gigabytes of information from Dr. Welcher. We gave any reference material, whether he was going to use it or not. We gave all studies, all data, anything that he considered, even if it was irrelevant, we provided to the defense. It was an extraordinary production. I've never seen a more complete production. But Dr. Welcher gave his entire file to the defense with all of the raw material, all of the studies, all of the reference material. It's not limited to this report. As you can see, Dr. Welcher is extraordinarily thorough. You can see in the letter report all of the different things that he looked at, far beyond what any other expert has looked at in this case, far beyond, I dare say, what ARCA even considered in this case. And so it is obvious, but maybe not to the defense, so I will narrow it, that Mr. Welcher, Dr. Welcher, cannot come in and talk about the opinions or testimony of witnesses as it relates to their statements. So, for example, as Attorney Alessi points out, 1C, he won't be able to come in and would not want to come in and say that the witness did not see damage to the taillight. She'll testify to that herself, that there was no damage. In fact, all the witnesses did not see damage to that taillight. As to 2C, the testimony of Jen McCabe, that is for reference. Testimony of Jen McCabe is for Jen McCabe and the jury. He will not be offering testimony of Jen McCabe or offering anything that relates to it. Similarly, 2.1 regarding Julie McCabe and grand jury minutes, he won't reference grand jury minutes in the abstract, let alone the details of it. Number 4, he will talk about the weather if it is already in evidence. It's a proper basis for an expert, but he will not be talking about the frozen ground. Similarly, in 4G and H, this is reference material regarding Julie Nagel and the Ford occupants. They'll testify to what they did and what they saw. And the people inside 34 Fairview, even though every single witness says John O'Keefe never came into Fairview, that is left for the witnesses, not for Mr. Welcher. And so the basic argument of the defense is that this biomechanical engineer should not be testifying using his principles and his education about demonstrations. What is suggested is that there's no evidence that he ever engaged in these demonstrations before, that they were exclusive for litigation, they weren't tethered to a specific study, and the methodology for each one is not outlined in a report. I wasn't sure if he was talking about Dr. Welcher or he was talking about the ARCA experts, because when I'm looking at the ARCA report, which apparently they're very comfortable with, we don't even know which witness did what. Importantly, when we look at the ARCA report, you have one witness who decided to build a potato cannon for no reason that we know of. No evidence that anybody threw a glass, but apparently it was a cool idea, he cited on the stand. That wasn't tethered to a specific study. That didn't lay out the methodology of the potato cannon. That wasn't repeated or validated. There was no specific literature that was referred to in that report. And yet, not only were they allowed to offer this evidence, it wasn't inappropriate. Now, it would be nice to know a little bit about the potato cannon, maybe a picture or a video or some specs on it, or maybe some details on how it actually operated. See, these are the things that Dr. Welcher provides to the defense. He doesn't just provide the information, the raw data, and the studies. He actually shows the demonstrations. He doesn't hide from his basis of his opinions and conclusions, he shows and demonstrates them with videos and pictures and photographs, quite unlike ARCA, where it is just simply a conclusion based on just trust me. And so when you look at the production by Dr. Welcher, it is not comparable to the standard that the defense accepts for their experts. He is a biomechanical engineer. That is a combination and study of engineering and physics and science. And it also details medicine. He's
God,
not a
Hank,
medical
you're
doctor.
fucking killing me.
He's not diagnosing an injury, but it includes all of those arts.
Exactly.
Now, this is the same thing that ARCA says in their report. If you look at their report, they talk about the study. And they outline what they believe the study of being a biomechanical engineer is all about. In fact, one of the complaints by Attorney Alisi is Mr. Welcher's drop test. If you look at the ARCA report on page 10, they do the very same thing, except that they don't show it, don't actually demonstrate it. It's pale in comparison, but they give the conclusions and they give a chart. No different. And so there are no medical diagnoses by Dr. Welcher. These are his opinions based on his study of the evidence, and he goes to the extent of actually demonstrating those different assessments that he has made. In particular, the defense takes issue with basically everything he's done. And just as a general perspective,
Yeah, we take issue with everything he's done.
they would like the ARCA witnesses to come in and say that the injuries were not consistent with striking the taillight of the Lexus. That's what they want to say. Dr. Welcher's opinion is different. It's the same engineering, it's the same science, it's the same concept. It's just a different opinion than they like. So if they like the opinion, all of these standards that Attorney Alisi is insisting on are excused, but if they don't like the opinion, somehow should be excluded. They're really polar opposites when you think about the perspective and the opinions they give. They both have a different opinion about the taillight causing the injury to Mr. O'Keefe's arm. One the defense likes, one they don't. It is the same science, same study, same analysis. And so if it's acceptable for ARCA, it must be acceptable for Dr. Welcher. Dr. Welcher actually downloaded the text stream data. He didn't ignore it. He didn't know that it didn't exist. He didn't fail to consider it. He actually downloaded it himself. He is experienced. He looked the material, studied the material. The text stream data is critical in this case because it shows time and place with the new information that we have. So we know from the Waze information exactly where that car went from the waterfall to the flagpole. We know where it did and didn't stop along the way. We know, based on the phone data, Mr. O'Keefe's phone data, when he was in the car until.
Bullshit.
We have all that evidence.
No, you
and
don't.
as a bioengineer, he can consider all of that technical data, which will be introduced through other witnesses at trial before he testifies. And it's important. The location and timing of that car is important. This is all science and data. It's not witness testimony. It's science and data. And it puts that car at that flagpole at the time Mr. O'Keefe is there with his cell phone, locked into the Bluetooth in that Lexus until he gets out of the car after 12:30. And within 2 minutes, we allege this collision occurs. And there's Apple Health data, there's location data, there's cell phone battery temperature. It all coincides. He should be able to consider these things in his study. This is what he does.
Nicholas.
The demonstration at Meadowbrook, John O'Keefe's house, is depicted by measurements which has been provided, science and data, by the ring videos, which will be independently admissible. And we see the gentle nudging of that Lexus into Mr. O'Keefe's car. And there has been allegations, claims, suggestions that that's where the taillight may have broken despite the other contrary evidence. You can see in the presentation, he actually shows not only the nudging in the car leaving through the ring video, but analyzes it, and you can see exactly where those two cars came into contact, and it wasn't the taillight. You can see through his demonstration or through his study of the materials he presented that the snow is on the back of Mr. O'Keefe's bumper until the nudge, and you can see the exact spots where the snow comes off. This is science and data. This is an opinion. This isn't witness testimony. And the jury should see that very evidence. It'll be admissible not only through him, but through independent witnesses. The defense takes issue with Dr. Welcher providing an opinion that the lacerations and cuts are consistent with the geometry and orientation of the right taillight. There has been many claims about alternative sources, which the Commonwealth disagrees with, as to those abrasions. But if you've seen the PowerPoint that's been presented and provided to the court, will be presented to the jury, it shows the symmetry of the arm and the location of the arm, the height of the broken taillight, and it shows with great continuity the height, location of that broken taillight, and how it relates to a bent arm. And that is based on engineering, biomechanics, the same things that ARCA employs. They just didn't do this. And so that's not witness testimony. That's not beyond the bounds of anything. That is powerful evidence, and we intend to introduce that. And then, as I mentioned, finally, the drop test. This is the same information that ARCA proposes in their report. For some reason, I don't think that was offered at evidence at trial, but it's clearly within the bailiwick of this expert. And so we will file on Monday a PowerPoint presentation redacting all the inadmissible parts of it, which is witness statements. And we expect to present the demonstrations to support the opinions as corroborative evidence of those opinions rather than just naked opinions.
Shut the fuck up. God.
And there will be no trial by ambush.
God, we'll suck you off
we
too,
will
whatever
be
we gotta do
studious
to
in
get
getting
this
that
in.
information to the
Oh,
defense. We
God.
would like them to be as studious getting us the ARCA information. It does concern me delaying that information because, as Attorney Alisi eloquently said, you need time to prepare. We know he's a very prepared attorney. We'd like to prepare as well. And if we wait to get records and information and know who wrote what part of the report, we won't be prepared. There's a third engineer in their team that wasn't called. We'll have to add him to the witness list if he has any relevance. We won't know until we question those witnesses. So I think I'm also inclined to ask the court to consider we have that questioning well before their testimony. But we will meet our commitment and provide those slides on Monday.
All right. And Mr. Alessi, again, you've already said you agree to talk to Mr. Brennan about the reciprocal discovery.
Yes.
Okay.
May I be heard your response?
Sure.
Thank you.
Okay. What do we got, Alessi? Come on.
Like with Dr. Welcher's report, what Attorney Brennan did not say is even more important than what he did say moments ago. He didn't state or even address where is the methodology employed by Dr. Welcher tethered to a study, the scientific literature. He kept using the phrase, it's science and data, quote. Someone alleging that it's science and data doesn't even begin to approach that the methodology is established in the literature or satisfies the Dalbert-Lanigan factors. So, Your Honor, on the record before you, there's no better evidence that that tethering doesn't exist than the absence now for the fourth time upon challenge of that in Attorney Brennan's comments. That dooms Dr. Welcher. Now I want to address the false equivalency argument of Attorney Brennan. Attorney Brennan said falsely just now that the ARCA report does not set forth the methodology. There are 14 footnotes in the ARCA report. I just looked at them again. Footnotes 1, 2, and 3 tether the methodology of the ARCA experts to the literature. The methodology is documented. I do not understand how an attorney can get up and say a report doesn't have something without having a basis for saying it on a key issue that is disputed. Attorney Brennan also falsely stated that ARCA did exactly what Dr. Welcher did with regard to medicine and medical issues. That is completely false. ARCA, as is clear as day from the report, and I'll repeat it, did a force net equals mass time acceleration calculation and said the forces that come from 15 miles an hour, 24 miles an hour, and then so the unknown is the force, the F in the calculation. What is known is the M and the A. The M is the mass of the head and the mass of the arm. The mass of the head is 11 pounds. The mass of the arm is 11 pounds. You then take the acceleration theory, even assuming the theory of the Commonwealth, which we can test, which is it's 15 miles per hour or 24 miles per hour. You multiply the mass times the acceleration, and you get a force. And then they said this force is expected to cause or not cause these types of injuries. That is a proper biomechanical engineering analysis. The ARCA experts didn't get into pattern recognition with regard to the wounds, the orientation, etc. But most importantly, there is no equivalency between what ARCA did and what Dr. Welcher did. With regard to Mr. Brennan stating, quote, this is what he does, referring to Dr. Welcher. The question is not, is this what he does? The question is what he does rooted in science. And what it means is not just any science, it has to be a commonly accepted, his methodology commonly accepted or satisfying the Dalbert factors. And Mr. Brennan did not contest one aspect. He didn't say, Your Honor, here is where what Dr. Welcher did can be found. It's commonly accepted, either in court opinions, which the court can take judicial notice of, or in peer-reviewed literature, because it's not there. And with regard to the 5 non-exclusive Dalbert factors, I covered that in my presentation in the beginning. I'm not going to repeat it, only to say that Mr. Brennan didn't address any of those 5 factors to show a proper foundation for that. With regard to what Mr. Brennan called arm experiment, relating to a bent arm, relating to injuries, I understand what Dr. Welcher did. The question is not what did he do, but is it accepted in the medical literature? So with regard to the arm experiment that Mr. Brennan just went through, he talked about it, but he didn't mention once where that's rooted in the literature. He finally concluded by saying, this is within the bailiwick of Dr. Welcher. I don't know what this is, but bailiwick is a tautology. It doesn't say anything about whether what he did is rooted in the literature or that it satisfies the Dalbert factors. So, in conclusion, Your Honor, I go back to Rentala, I go back to Meeks, I go back to Case of Caravan. The Commonwealth has not today, not before, this is their 4th time, has not satisfied what the Supreme Judicial Court requires in these instances. And what it has come down to is the defendants, which stands in a different position. This equivalency between ARCA, I've shown, and it's easily documented, the court can see it, that contrary to Attorney Brennan's false statements, ARCA did cite to and tether their methodology to the literature. But when you have a defendant on trial for the seriousness of the charges here, to have no methodology, to have no tethering to the literature, that's, as Your Honor knows, the gatekeeper's function to stop that those opinions from going to the jury to ensure not what the defense has created, but what the Supreme Judicial Court has created, which is the purpose is to allow for cross-examination and a fair trial. They haven't satisfied their burden. They have the preponderance of the evidence burden, and the consequences should be borne by the Commonwealth, not the defendant.
Okay. Go ahead, I'll hear a quick response.
What the fuck? I don't understand. I don't understand.
Regrettably, I know Attorney Alisi has decided to join the fray of disparagement. Now, he has said 3 times that I've made false statements. This isn't the first time
They're picking on me.
that Mr. Alesi has tried to portray the Commonwealth as being disingenuous, because they know full well this is being covered by the media, and they want to create a sense to dehumanize anything that they don't like, whether it's the government, the prosecution, the witnesses, or the evidence. There's no place for it. 3 times. This follows when he made representations, reckless representations in court, that Brennan lied 10 times. We found some of those transcripts, and I took enough dignity not to mention it, because I didn't think I needed to, that the transcripts were not even accurate. Mr. Alisi was actually wrong when he was claiming I was lying about reading reports. Now, I don't want to stand up here and have a dispute, but when you use words like false statements as an officer of the court, they better be supported. That is a strong statement to repeatedly make, and it's a tactical one. It's purposeful. Attorney Alisi is joining the fray, and that is all part of the strategy here. Now,
He's joining the fray. I'm gonna play
if you look at page 13 and 14 of Dr. Welch's report, perhaps that was missed in the review. There are resources in that report that number 26 different items of resources. And so if we're talking about support and tethering, it is at the end of the report. It's not footnoted like ARCA, it's at the end of the report. It's all there.
All right, thank you. So we're going to move on to try and get some motions in quickly. The motion regarding the chalks, is there an objection to the Commonwealth's motion requesting the use of chalks and directing both parties to provide visual presentations in chalks prior to using?
Oh.
No objection.
Okay, thank you. 583.
Great band, the fray. Great
Is there an
band.
objection to the Commonwealth's motion Limine to allow the expert Celebrite demonstration? We had it before. Is there an objection to that from the defense?
Yes, Your Honor.
Okay. Is this something that can be done quickly, or is this something you need more time on?
15 to 20 minutes, Your Honor.
All right, so we're going to have to table this. We may end up coming back tomorrow.
I can do it once. You tell me what
No,
you're on.
let's
Why can't we
let's
stay
see
till
what we can get
5,
before the
Bev?
lunch and break.
Bev
The
wants a
paper
lunch
number
break.
585, it's the Commonwealth's number
Bev's only
11.
worked for 1 hour and 30 minutes.
Motion eliminate to admit the victim's out-of-court statements relating to John O'Keefe's state of mind, the quals, bins, types of cases. So is there an objection from the defense on that? If there is, I'll hear it quickly from the Commonwealth on its motion.
There is, Your Honor.
Okay, so I'll hear you on this, Mr. Brennan.
This is unbelievable.
Evidence of Mr. O'Keefe's state of mind is particularly relevant in this case.
He was drunk.
In addition to the charges, this has a domestic aspect to the case. We know from his statements that he was in a relationship with the defendant. We know from the statements that there was a tumult in that relationship, and many of those statements are reduced to writing. The state of mind of Mr. O'Keefe is reflected in those statements. There was no time or reason to fabricate. You can tell by the content and the volume of them that there is a legitimacy to them. And it is clear, based on that and other testimony, that he was in the course of attempting to end the relationship with Miss Reed. And so his statements, especially over the course of the day of this incident.
All right, so what's the time frame? It's so over the course of the day.
All right, so what's
I realize that the Aruba incident is too remote and you're not using that, but what's your time frame for me to be able to evaluate
As
this?
far as his messages, I will
Or
look.
the statements or the evidence that you're trying to put in under this doctrine?
His niece would testify, as she did in the last trial, about the tumult in the relationship.
Oh, come
And we'd
on.
introduce the same text messages that we introduced at the last trial, reflecting Mr. O'Keefe's state of mind about the relationship.
Okay. How about him lying to
And
her?
there would be nothing different from the last trial, other than the fact that
She
we
had no
are
idea.
not going to pursue the Aruba information. So it is actually a narrower time window than before.
Okay. All right, I'll hear you, Mr. Jackson.
Thank you, Your Honor. I may be a little more brief given that explanation by Mr. Brennan than I intended or anticipated. I will say that where the Commonwealth's motion fails is in its explanation as to the relevancy and how it comes in under a state of mind theory. These are obviously hearsay statements.
Thank you.
In some cases, they are multiple hearsay statements, or potentially multiple hearsay statements. John O'Keefe's state of mind is irrelevant unless there is a specific admissible evidence that he communicated those statements, and we'll have to sort of take them as they come, given I don't have the full breadth or an understanding of the full breadth of the information that is being sought. Mr. Brennan just indicated it's going to be consistent with the last trial, so that gives me some target range. But without knowing more, under a normal hearsay or even state of mind analysis, it's irrelevant unless there's a specific admissible point that he communicated that, or point at which he communicated that state of mind to Ms. Reed. She was aware of his state of mind, and very importantly, that the information that was communicated to her was of such a nature that she would have acted on it in a manner that's consistent
That's
with.
what we were talking about, the bins, calls, those points that need
Correct.
to be made.
And that's what I'm getting to. With that last point, and to drive this point home, that's preposterous. The idea, there is no evidence to support that last point, that this type of information, let's say, for instance, it's information that he wanted to break up with her, or he was mad at her, or he was angry at her about something, some incident, some specific thing having to do with feeding the kids donuts or not feeding the kids donuts, or they had a what was considered, what was testified to in the first trial as a very normal row or argument about something as insignificant as that. The fact is, the state of the evidence is that on the night in question, it's uncontroverted by even the Commonwealth that the two of them were getting along extraordinarily well. The facts are borne out in both videos that are uncontested. They're borne out in witness statement that went uncontested, that they were affectionate, they were happy together. They were described by basically everyone on the Albert side, the McCabe side, as well as individuals who also saw, that were not related to those families, who also saw Karen and John interacting throughout the evening. And they all said that they were getting along very, very well. One person described them, the court may remember this phrase, as lovey-dovey. I think that it's pretty clear that through this testimony, or through this rubric of bringing in John O'Keefe's state of mind, the Commonwealth really wants an opportunity to call one or more or several witnesses who will basically say he wanted to break up with her, she was not a good girlfriend, he didn't like her. That is an assassination of her character. Couch it in whatever terms he wants, but that's really what it is.
I've never
These
seen...
witnesses will have no corroboration, we expect. I'm leaving the text messages aside. If there are text messages between John O'Keefe and Karen Reed, that may be a different analysis, but certainly where it comes down to the witnesses, like the niece, they'll have no corroboration or no documents, no writings, no recordings, no videos, no audios, nothing but their word. And to allow a witness to walk in and to say negative things about Miss Reed with no way of verifying those statements is highly prejudicial. It's not just prejudicial, it's far more prejudicial than it would ever be probative in this circumstance. Even if he did, even if the evidence was that he had discussed breaking up with other people, there are two major impediments to the Commonwealth's request. First, there is no evidence that, for instance, from the niece, I don't believe that there will be evidence that that was imparted, or those specific conversations were imparted to Ms. Reed. The state of the facts very clearly show the opposite. If we look at the circumstantial evidence, the videos of Ms. Reed at both C.F. McCarthy that night, as well as at the waterfall that night, showed the two of them getting along, completely inconsistent with two people who were talking about breaking up. John O'Keefe wanting to dump her and her knowing that she was going to be dumped, which is what the Commonwealth is generally suggesting. And second, there's absolutely no evidence that even if she thought that John O'Keefe, if she was aware that John O'Keefe was unhappy in the relationship, that he might want to break up or in the relationship, that would have been a catalyst for murder. And that's where the rubber meets the road in this analysis. That's what the Commonwealth has an obligation to prove before this evidence is admissible. And that's a ridiculous stretch. They'd been together for about 2 years, notwithstanding the prior relationship many years earlier. She had her own career. Karen Reed had her own money. She had her own life. She had her own job.
Way more than he did.
Had her own house.
Yeah.
She was not dependent upon John for anything.
Nothing.
Not for money, not for
not for the dick either.
They were, at the end of the day, just dating. The fact that she had some text messages with other individuals, or an other individual, Higgins, is actually evidence that she knew she had options, and John O'Keefe likely knew he had options as well. Both of these individuals were not tethered to each other in a way that if one wanted to break up with the other one was going to murder the other one.
Exactly.
And that's what the Commonwealth would have to prove to make this admissible. There's no suggestion in the facts
to bring kids into this
that Karen Reed
fucking
would kill
sick.
John O'Keefe rather than simply break up with him or allow him to break up with her.
You dumped me. I'm going to kill you.
Way. It's absurd.
Absurd.
And there's no evidence that she was angry with him that night before she got out of her SUV. All of the evidence that we have, all of the uncontroverted evidence that we have establishes exactly the opposite. They were a loving couple out one evening, having drinks with friends, in a good mood, and happy with one another.
Give Karen Reed way more credit than
We cite a case called McGraw, M-A-G-R-A-W. And just for the record, I'll state the site. I think it's at 426 Mass 589. And the McGraw court provided a very defined quote that I think is illustrative for our purposes, Your Honor. Quote, a murder victim's state of mind may be material to the defendant's motive, but only if the defendant knew of the victim's state of mind, and most importantly, the court's words, not mine, and most importantly, would be likely to respond to it. The best evidence that this second prong cannot be met is the fact that the Commonwealth will attempt to bring in these prior statements of John, which, if believed, Miss Reed never acted on. In other words, they're going to bring in prior statements to say she would necessarily act on it and act on it in a violent way that would take someone's life.
Yeah.
But at the same time, they're stuck with the very clear fact that if in fact that's true and it was imparted to her that he was unhappy in the relationship, she never acted on it.
No
Not
violence.
once. And the moment that we do have frozen in time that we can go look back on is the night of January 29th, or the evening of January 28th, going into the early morning hours of January 29th, in which they were both getting along perfectly well, completely in opposite of what the court in McGraw defines as necessary for that sort of evidence to be admissible. The reason that the Commonwealth's theory for admission doesn't make sense is because it's not really their theory for admission, I suspect.
The Housewives of Atlanta are
That
just
they would like to
laughing.
have someone or some people get on the witness stand and assail Miss Reed's character, make her look bad, and say that she was either a bad girlfriend or that John was not happy with her.
Bad girlfriend.
It's an attempt to inflame the jury, to make them dislike her for something that has nothing to do with the evidence that she hit him with her SUV on the night in question. And it's a very transparent attempt We strongly believe that this attempt does not meet the evidentiary standards that are required. The Commonwealth cannot meet those standards, and pursuant to McGraw and its progeny, we would ask that this evidence be deemed inadmissible.
Okay. Quick follow-up.
It seems the thrust of the defense argument, and I appreciate their advocacy and argument, but it's not shared by the Commonwealth, is that they were lovey-dovey and got along well that night. Well, at the time of this incident, it seems there's substantial evidence that Ms. Reed was not happy with Mr. O'Keefe. On 2020, transcript page 43, line 1, she was asked, would you say that you were angry with John that night? Her answer was yes. She was asked by Ms. Voss on June 20th, 2023, about that night, or the day before, and she says, I was temporarily frustrated. It wasn't an argument. She also says to Ms. Voss, were you worried at him or pissed at him or both? I was pissed until I fell asleep. Now, in addition to her anger, she specifies some of the tension. We heard from the testimony of Jen McCabe that when she gave directions to John O'Keefe, she mentioned a mother of a child who Mr. O'Keefe had a prior relationship with. That this is minutes before we allege the collision happened. And so in the interviews that she has provided to these different outlets, she discusses the fact that she hears this information and that there was an issue or some type of interaction about the fact that he was previously dated another woman. And this is a conversation that takes place minutes before the collision. And so we have statements from the defendant herself that show the discord in the relationship, the anger, being pissed, the motive, without leading them because it's unnecessary. There is substantial corroborative evidence. Not only that the text messages, which are corroborated by the niece's testimony, but the imminency of it, that this is happening in real time moments before John O'Keefe's death. And so all of this should be admissible. It's all supportive of each other.
Your Honor, if I could just correct the record very quickly.
Sure.
If anything Mr. Brennan just said was true, he might have an argument. My goodness. It's important to get some of the facts right. You got to get some of them right. The conversation that he just referenced with Jen McCabe was the next day. It was the next morning, not minutes before the collision. He's read the every time he stands up, he says, I read the I wasn't there, I read the transcripts. We got to hold him to that burden, Your Honor. You got to get the facts right. That conversation with Jen McCabe was the next morning after John O'Keefe had been found, after he didn't come home.
I'm sorry, I just need to correct.
I'm sorry. I was talking to my client real quick. I'm not quite done. This was during the time after 5:07, after the SUV leaves, we see One Meadows, and Jen McCabe and Kerry Roberts get together. And as they're looking for them, as they're looking for him and searching for him, that's the point at which they have the conversation about being some other woman, or why he might not have come home, or what her mindset might have been at the time. It's after the fact, well after the fact. The other issues concerning Karen Reed's statements about being upset, or in Gretchen Voss's words, were you pissed at him? It was in context of when. When were you upset with him? When he didn't come back out, when he didn't come back to the car. After she left, she was angry. That's where all the voicemails take place. That's what she was talking about, having been angry. There is no evidence, none whatsoever, no evidence in the record. I want to make this as crystal clear as I can. No controverted evidence, no suspect, no evidence at all that John O'Keefe and Karen Reed had a single crossword that night before he ended up missing and she went home. Before he ended up walking out of the car, going toward the house, and she ended up leaving when he didn't come back out. Zero. The only evidence that was propounded throughout that entire day was hours and hours earlier that morning dealing with, did you feed the kids donuts? And yeah, I did. You know I don't like it when you feed the kids donuts. She was spoiling the kids. It was not enough to enrage anybody. It's ridiculous. And the evidence that it didn't enrage anybody is the fact that they ended up later that night together in a lovey-dovey environment, getting along fine, getting along wonderfully. That's why the Commonwealth cannot make their burden to establish that this was the type of information that she would have, by necessity, acted on, and not just acted on in any way, acted on in a way that's consistent with their theory that she would have received the information and murdered him for it. That's the hurdle over which the Commonwealth cannot leap for the admissibility of this type of evidence. It's far, far more prejudicial than it is probative.
Okay.
Before accusing somebody of getting it wrong, the person accusing should be right. I know that Mr. Jackson, Attorney Jackson, was present during the Voss interviews, but apparently they haven't listened to the interviews or read the transcripts. Page 88, line 22. Not the next morning. When Jen was navigating John to the Alberts, she said it's near Ashley's house. Ashley and John had hooked up prior to John and I dating. Similarly, page 92, line 1.
Call that B to the stand.
Totally contrary to what you just heard.
Bella's mom.
Totally. There was a woman who was a mother to kids that were close to John's kids who lived very close to the Alberts. In fact, when Jen was navigating John to the Alberts, when I was driving, she said it near Ashley's house. Ashley and John had hooked up prior to John and I dating. She broke up briefly with her husband. Not my words.
All right. So we're going to break. We've got a lot of ground to still cover. I suggest that we take the personal attacks completely out of this. Hold on. Both sides. Both sides.
Who's personally attacking?
I want to get through these motions today. If we don't, I'll bring you back tomorrow. I'll bring you back Monday. Let's get through these motions.
You guys,
leave all the attacks, all the falsehoods, all of that. Leave it all aside. Let's focus on the motions and get through this. So I'll see everybody at 2.
If I could say one more thing. As the court ponders this last issue.
I'm not even thinking about it for the next hour. Let's leave it.
Alan Jackson is like, this is the most craziest shit I've ever been a part of. Like, if Karen Reed doesn't move from Boston, fucking Massachusetts, period, doesn't take her parents and her family and up and go move to LA and work for Alan Jackson in some capacity, like, and get the fuck out of there. Okay. Like, this is absurd. This is nuts. I mean, I feel like we're watching little kids, like high schoolers. I feel like high schoolers are all on the stand. I feel like, this is so just. When Hank gets up and takes the stand and starts talking about, unless she wants to get in on the fray of blah, 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 disparaging people, right there, Bev should be shutting that shit down. Bev needs to stop you cannot let him get up there, okay? Because I'm going to tell you something. Somebody put a little fire under Hank's little ass and said, listen, you need to start using this video time, this media attention, we're live here on, all these channels. You need to start fucking taking shots at the defense. Okay. Lally didn't do this. Go back and watch. Lally wasn't doing this. Lally fucking didn't say shit, man. Lally wasn't doing this. Hank, zero decorum. And then what I see that you don't think that Yannetti, Little, Aleshi, and Alan Jackson are going to defend themselves? They're defending themselves. They're defending their client. In a hearing that we're supposed to be talking about what's in and out based on the evidence, with what's admissible, inadmissible, what the rule, like, this is absurd. But we're hearing little, hey, you want to disparage me and you want to take shots at me. Like think about that in the form of like an athlete. We would never get up on a podium and say, that man called me a bitch. And I just, like, what a fucking pussy. Puss. Put that over there in the fucking buffer zone. Pussy Brennan. Like, somebody just go buy a bunch of badge sticks and dicks on the end of pencils. And it's just ridiculous. This is horrible. This is I have my feelings. Oh my God, you're doing. Ugh. Little tattletale. And they're not, and you know what the thing is that they're not even doing anything. He's just making this shit up. Your dense brain. And because he doesn't have anything to say, he doesn't have any arguments. He has to go there and then he just word salads. So I think whoever would ever do this for $75,000, there is no way that Hank Brennan's only getting $75,000 to do this. Okay? No way. There is nobody would do this job for $75,000. Just come in and I'm just gonna take this case on and do all this work for $75,000. Karen Reed's friends and family and the rest of the world over here could raise $75,000. Like I'm just saying, like they did like that. And how much money this all costs. Think about that. Think about that. Hank coming in here. He doesn't even let those two Muppets talk. ADA McLaughlin and ADA Lally. He doesn't even let them speak a word. Hank Brennan is doing all of this. So Aiden says, well, that was interesting. So I don't know. I'm going to take my break here because this is going to be back like, I guess, to like an hour. So I'll run it and just leave this on, I guess. And that way, if I want to bounce around, do something. It's 1:03. Bev's like, we're going to bring him back tomorrow. We're going to bring him. Bitch, why don't you just stay and finish it up for an hour? Okay? Like that's just, can I tell you how much people like that is why the world does not work smoothly. People like Bev is why when you go to get your driver's license, it takes you fucking 4 hours. Okay? People like Bev's mentality. Okay? Where is your brain to think that we're just going to call people back tomorrow when we could just have people here for an extra hour? Absurd. Do you understand that Bev, technically, we had the whole little Karen Reed and Turtle Boy going on before even this happened. She's maybe worked 2 hours today. Let that sit in. She had a 20-minute break. They didn't start till after 10, and it's 1 o'clock. She's worked, 2.5 hours? You would have thought that she just went through literally 2 days. Oh, she's the reason that I can't get my license in an hour. She is sloth badge. I'm telling you. Mark my words. This woman is, you clone, and there's so many people like her like out there, man. Hank Brennan, though, he's lying. He's lying when he says, oh, we're going to redact this. No, I'm not going to go get that. He's lying. He is lying. Okay? He just needs her to allow it to begin. Okay? And then all that stuff's going to happen at sidebar when they're just objecting. Lana, look up Olivia Lambo's new post. I don't even know who that is. Does she drive a Lamborghini? when you said that, you know what song it made me think of? So I'll end on a song because I'm just notorious for that. Call me Van Gogh. Let's play some Fetty Wap. There we go. I think it's this one. The opposite of that, of what the defense would like to propose. So what is that, in quotes? The defense would like to propose. They've not proposed anything. That's what I said. I said, what the fuck? The federal investigation conducted a thorough investigation, as Brennan also acknowledged, and they found zero evidence of Karen Reed's guilt. Hank Brennan and the DA's office continued efforts to ignore that glaring fact is troubling and reaffirms the fact that they're not pursuing justice. They're pursuing a patsy. Pin it on the girl, the outsider. The feds found zero evidence of Karen Reed's guilt and also determined and proved that Karen Reed did not kill John O'Keefe with her car. Whether or not the federal investigation is closed does not change the fact that regardless of how hard Hank Brennan pounds his fist on the podium, and just in case there was any doubt in your mind, here's words straight from the horse's mouth in a letter from the U.S. Attorney's Office in response to the DA office letter where he attempted to belittle and dismiss the defense's third-party culpability theory. Beeland writes to Dear Miss Beeland, this response is to your June 21st, 2023 letter concerning your, I can't even read this, punitive request for a recusal of the United States Attorney's Office for the District of Massachusetts from the pending state criminal matter Commonwealth vs. Karen Reed. As you indicated, the Department of Justice Office of Professional Responsibility informed you that they had referred your May 18, 2023 letter to my office for whatever action I deemed appropriate. Consistent with the terms of the referral from OPR, I contacted Acting United States Attorney Josh Levy. Based on my understanding from what that discussion with U.S. Levy was, his office has a very different opinion of the circumstances in this case than as presented in Mr. Meatball's letter. His office has not reached any official determination whether prosecution is warranted, but they believe it is essential to continue their investigation given the information of which they are aware. At this time, we see no basis for a recusal in this investigation. Thank you for your contact information and blah, blah, blah. So yeah, that was all back in the day. That's an old ass letter. That's old as fuck. That's from 2023. I don't understand. The FBI doesn't investigate murder cases. Peace. Peace. Wait, so do you guys want me to leave this thread going? Yeah, I agree with that, Mystery. Yeah, he thinks he can dish it out. He is the cheater who constantly accuses his girlfriend of cheating. Yes. Yes. Yeah, that's funny. This motion in limine, all this stuff, all these motion limines, Bradel said it best, if you guys were listening at the beginning, when Bradel was on there. Bradel said, guess what? I've never seen, in all my years doing this, that the Commonwealth is literally trying to, they're using motion limines to, circumvent and try their case. And he's never seen that. And you know who else is doing that, guys? Idaho. All right, yeah. I'm going to end this one. I'll just do, at the 11th hour. Mm-hmm. Yep. I'm going to end this one, then I'll just start another one at 2. That's how I'm feeling right now. I mean, we're watching little kids play, little kids argue. And here's Bev. Like, she's like, ugh, this is how I like my courtroom. Like, did you guys see a total difference in that dude that was up there, that was the judge before Bev took the stand, took to her little area, took to the bench? I mean, he commanded that courtroom. Bev, oh, Bev used to be, she was from the public defender's office before she got into this role. Yeah, he seemed like a real judge. Yeah, right? It's crazy. I'll just watch everything Karen read on my lunch break here. So right now, they said it was going to start in 45 minutes, so come on back, watch kids play while Bev referees. She's a public pretender. That's what it seems like. I think that anybody that had this woman as a public defender should come forward and talk about their experience. How about that? Let's go look at the docket. Let's see who Bev represented when she was a public defender. I bet you so much of her shit ended up in plea deals that were like, it's one thing. Plea deals happen a lot. But I want to talk about like bigger cases. I'm curious to know what Bev did as a public defender. Just doesn't seem like her cup of brain and tea and, So, all right, guys, until the next time. They were extreme cases. Yeah, I want to, Microdots, if you have any of those, like back in the day, can you email me some of those? I would love to see what they were. I don't know if you have my email, but it's the Mind Challenge at Gmail. There you go, the Mind Challenge at Gmail. Yeah, if you have any of those, I would love to take a look at that. That interests me. Yeah, send me an article, and then I'll dig from there. Oh, thank you. Appreciate that. Okay, yeah, send me that. Thank you so much. All right, guys, we'll see you back here in a little bit. Peace. Hit the thumbs up on your way out.